Okay. Hey guys. Sorry, I am late. And Penelope, y'all hear, bro? When you're in a hurry, everything goes slow. Trying to run an errand, you know what I mean? In between, court, because it lasts all day. So here we go. Hey, October 50, Lady V, come back. I'm glad you're a little bit better and you're here. But guys, I had to run an errand, and when you're in a hurry, what happens? Everything goes slow. And find my shoes. Thank you. I can now find my Nike Slide Gel. That's my favorite pair of shoes. In the heat in the summer. I can't find them, so now I have to wear my flippy floppies. I'll be right back. All right, let me fast forward till the judge gets here. All right. Okay.
I've also explained to her that she has a right not to testify, that she doesn't have to get up on the witness stand, that she can stay at counsel table and remain silent. That's her right. That's her choice. I gave her time to think about it, to reflect on it. She had questions. I answered those questions. We had a good dialogue and conversation on this particular topic. She's advised me that she wishes to waive her right to testify. She's not going to take the witness stand.
Mr. Business, your attorney tells me that you choose not to testify at this phase. Is that correct?
That is correct.
Okay. You understand that you have a right to testify, and you also have a right not to testify. And if you don't testify, your choosing not to testify can't be used against you. Do you understand that?
Yes, I do.
Okay. You understand those rights belong not to Mr. Freilich. They don't belong to me. They don't belong to the state. Those rights are yours and yours alone. Do you understand that?
I do.
Do you feel you need any more time to talk to Mr. Freilich about this decision?
No, I don't.
And it's your decision not to testify here today. Is that correct?
Correct.
Okay.
Please hit that thumbs up
Any
for
further
me.
inquiry the state would like me to make regarding that?
No, thank you.
Mr. Freilich, any further inquiry you'd like me to make regarding that issue?
Only if the court would inquire as to whether she felt any pressure or coercion in order to make this decision?
Ms. Shabusiness, do you feel you've had any pressure by anybody or coercion to make this choice?
No.
Okay.
Thank you, Judge.
I'm satisfied that Ms. Shabusiness understands her rights. She's had a full opportunity to speak with her attorney about it. And she's made a choice here today, freely and voluntarily, not to testify at this phase of the trial. And I'm going to accept that, and we are going to move forward. So I think how the matter would unfold then is when the jury comes back in, I'll ask Mr. Freilich if he has any further witnesses to call. Based upon what I've heard, the answer will be no, the defense rests, and then we would move to the state. And as I'm presuming the state is ready to call its first witness.
Yeah.
Okay. And then I did want to place on the record, because I was advised that when we excused Dr. Layton, we weren't on the record, but there was no objection to Dr. Layton. It's too late now. Both parties indicated there was no objection to her being excused, and that's what I did. Is that correct, Mr. Freilich?
That's accurate.
And Mr. Saunders?
Yes.
Okay, and then I just want to confirm, we don't need to go over these now. The jury has already been waiting a little longer than I told them they'd have to. But I did place on the on council table copies of proposed jury instructions, and then also just recently copies of what comes in the form of jury instruction 605B, but it's not a jury instruction, it's a proposed verdict form. Did both parties get a copy of those, Mr. Freilich
Yes.
and Mr. Saunders?
Yes.
Okay, we can discuss those at the conclusion of evidence, but at this time then, I'm going to bring the jury in. All rise to the jury. Okay, be seated. All right, we are back on the record this afternoon. The case is still with the defense. Mr. Freilich, do you have any other witnesses to call?
Your Honor, the defense rests at this time. No other witnesses.
All right, then the matter turns to the state. I don't know, Mr. Lizet or Mr. Saunders, who's going to be questioning the first witness. So, Mr. Lizet, your first witness.
Your Honor, the state calls Dr. Matthew Seipel.
Okay. Dr. Seipel, if you want to step forward here and
Please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God.
I do.
Please have a seat and state your name for the record.
Matthew Seipel. My last name is spelled Seipel.
okay, then the witness is yours, Mr. Lizet.
Good afternoon, Dr. Seipel.
Good afternoon.
How are you currently employed?
I am employed as a licensed psychologist with Behavioral Consultants Incorporated and the Wisconsin Forensic Unit, where I perform forensic mental health assessments on a full-time basis.
How long have you been with the Wisconsin Forensic Unit?
I began with the Behavioral Consultants and the Forensic Unit in September of 2020 as a postdoctoral forensic psychology fellow, and I've continued with those organizations since February 2022 when I obtained psychology licensure in the state of Wisconsin.
And you indicated that your full-time duties is to perform forensic evaluations. Is that right?
Yes.
What types of evaluations do you typically perform?
I complete competency to proceed examinations, mental responsibility or NGI evaluations, evaluations of people who are petitioning for conditional release from the state mental health institutes, as well as legal guardianship, and several types of juvenile evaluations.
You indicated that is your full-time employment. Do you know about how many of each of those evaluations you might perform in a calendar year?
And so I would say in total, I've completed over the past 3 years, roughly 1,000 across those types of evaluations. So in a calendar year, it would break down to typically at least 300 evaluations. About 3/4 of those would be competency evaluations. And then roughly, I would say another 10 to 20% would be NGI evaluations.
You indicated that you are a licensed psychologist in the state of Wisconsin.
Yes.
What does that process entail?
And so to become a licensed psychologist, one needs to complete a doctorate in psychology from an institution that is either accredited by the American Psychological Association or determined to meet equivalency of those accreditation standards. And then at the time that I obtained licensure, 1 year of full-time postdoctoral supervised practice was required. I believe that standard has changed, but that was the standard for licensure at the time that I gained my license.
And you indicated that you must have that doctoral degree. Where did you obtain that degree?
I was from Iowa State University.
And do you have, can you just go through briefly your education prior to that degree?
I completed a bachelor's degree in psychology from Cardinal Stritch University, as well as a Master of Science in Clinical Mental Health Counseling from Marquette University before completing my doctorate at Iowa State.
And doctor, through your professional work at the Wisconsin Forensic Unit, did you have an opportunity to work on the present case, state of Wisconsin versus Taylor Shabusiness?
Yes, I did.
How did you become involved in that case?
And so I was requested to complete 2 court-ordered competency evaluations in this matter.
When you say court-ordered, does that mean that the court is the party that retained you rather than either the state or the defense?
Correct.
Yeah, and when was that first evaluation? When was the first report filed?
That was in November of 2022.
And when was the second report filed?
That was earlier this month in July of 2023.
Can you, you mentioned that you were retained by the court to do a competency evaluation, and earlier you also mentioned that you do NGI evaluations. Can you explain for the jury the difference between those two types of evaluations?
Yeah, so those are 2 entirely different types of evaluations that are guided by 2 different state statutes. And so competency pertains to a defendant's current mental status. It is independent of the mental state at the time of the alleged offenses, and it pertains to whether or not the defendant presently has substantial mental capacity to understand the pending proceedings or to meaningfully assist in their defense. Whereas the state statute for NGI dictates it is about the defendant's mental state at the time of the alleged offenses, and specifically, was there a qualifying mental disease or defect that contributed to a substantial lack of capacity to appreciate wrongfulness of conduct or to conform conduct to the standards of the law?
And you indicate that you have substantial present experience in both of those types of evaluations. Is that correct?
Yes.
Now, they are different evaluations with different standards. However, are the materials used to evaluate those often similar?
I would say that collateral records are critical in both evaluations, although in competency, those records would focus most heavily on the present time and present functioning, whereas for NGI, it would be focused upon functioning at the time of the alleged offenses.
And can you talk about the records that you reviewed regarding Ms. Shabusiness for each of the 2 competency evaluations that you performed?
Yes, and so I reviewed the criminal complaint for the underlying matter. I reviewed all previous psychological evaluations that were completed in reference to this case, including competency and NGI reports from multiple examiners. At both times, I reviewed her contemporary treatment records from the Brown County Jail. And during the most recent evaluation, I also had the opportunity to review a discharge summary from a treatment episode at the Nicolay Psychiatric Center in 2021.
Did you, subsequent to the evaluation, were you also provided with copies of materials from an inpatient stay at Bellin Psychiatric or 2 different inpatient stays at Bellin Psychiatric?
Yes, after submitting my most recent report, defense counsel provided me discharge summaries pertaining to those 2 episodes of inpatient care.
And were all of those records taken into consideration when you either rendered your opinion or provided testimony at competency hearings in this case?
I would say that all of the sources that I mentioned initially were considered in reaching my opinion in my report. And then those Bellin records I did consider in preparing for testimony, but they did not alter any of the opinions offered in my report.
And in addition to reviewing collateral records, did you conduct personal interviews with Ms. Shabusiness?
Yes, I did.
And what were the dates of those interviews?
And so the most recent interview, I'm just referencing my report here, was on July 12th of 2023. And for the initial interview, I would reference to refresh my memory, that report from November of 2022, the date of the interview was November 17th, 2022.
And were both of those in-person interviews?
Yes.
And can you estimate approximately how long you met with Ms. Shabusiness in those interviews?
On both occasions, it was roughly 90 minutes, perhaps give or take a few minutes.
Doctor, when you were reviewing the records and ultimately when you had to come to an opinion in this case, had you encountered prior diagnoses that had been assigned to Ms. Shabusiness at various points in time?
Yes.
Were you aware that at some point in time she had received a bipolar diagnosis?
Yes.
And do you recall where that came from?
That was during her inpatient treatment at the Nicolay Psychiatric Center in 2021.
And Doctor, what did you note with respect to that particular diagnosis? Were there any concerns when you saw that?
Yes, a concern I had with that diagnosis is that for one to be diagnosed with bipolar disorder, it's specifically within the diagnostic criteria for that condition that the symptoms cannot occur exclusively in the course of substance intoxication. And I noted that there's multiple collateral sources suggesting that she was abusing methamphetamine very extensively leading up to that treatment episode. So I was unable to really see how the treatment providers could have parsed out to what extent any psychiatric instability derived from the methamphetamine use versus an actual underlying mental illness.
And did you have an opportunity to review the discharge summary from Nicolay Psychiatric?
Yes.
And in that discharge summary, is there a discussion of how she presented upon arrival compared to how she presented upon her release 21 days later?
Yes, it was noted that there was a remarkable difference and that psychotic symptoms were evident upon admission, including hallucinations and very disorganized behavior, although those symptoms were determined to be largely resolved by the end of that treatment episode.
Does that suggest anything to you with respect to the substance abuse that was indicated at the outset?
And so it's, again, difficult to disentangle to what extent that improved mental status resulted from any medication she received in the facility versus her mere forced abstinence from intoxicants.
Based on your professional education and experience of the types of symptoms that were noted upon arrival at Nicolay Psychiatric, can those symptoms also be associated with the methamphetamine use solely?
Yes.
So it's possible for someone to manifest those symptoms solely based on meth use without having any underlying mental health illness?
Objection
Yes.
calls for speculation.
Overruled.
Yes.
You indicated that you had the opportunity to review reports from other evaluators who met with Ms. Shabusiness and provided opinions in this case. Is that correct?
Yes.
Did you note whether or not any of the other evaluators shared similar concerns about the bipolar diagnosis assigned to her by Nicolay Psychiatric?
Yes, I noted that in Dr. Engen's mental responsibility evaluation, she took most specific and direct issue with the basis for that diagnosis. And she ultimately, in her report, offered that she did not see sufficient support to assign a diagnosis of bipolar disorder. I also noted that, for example, in Dr. Lucetta's competency report, while she did not necessarily completely rule out bipolar disorder, she also noted again that the substance abuse was a significant factor leading up to that diagnosis, and she merely essentially sought to rule out that diagnosis but did not assign it.
So I want to just sort of speak generally about bipolar. Can you describe for the jury what bipolar is and what is required to diagnose such a disorder?
Yes, and so there are two different types of bipolar disorder. There's bipolar 1 disorder, which is a more severe condition, and that is the diagnosis that has appeared in some of the records in this case. Bipolar 1 disorder is characterized predominantly by manic episodes, which are periods of it lasting at least a week, where more often than not, the individual has a significantly elevated mood. They may behave impulsively, erratically, have a decreased need for sleep. And in some instances with bipolar 1, that is alternated by depressive episodes, which typically last at least 2 weeks and are largely the opposite of mania. That means there's a persistently low mood, low energy, feelings of worthlessness, guilt, or hopelessness, things of that like. Whereas bipolar 2 disorder as hypomanic episodes, which are not as prolonged or severe as a manic episode. And by diagnostic criteria, someone must also experience depression in order to qualify for bipolar 2 disorder.
So is it fair to say that to diagnose someone with bipolar 1, we would have that expectation of seeing those prolonged manic episodes, at least one instance of a prolonged manic episode?
Yes, and it would need to occur outside voluntary substance intoxication.
Is it possible for a person who has been diagnosed with a bipolar disorder, is that the type of condition that could occasionally wax and wane over the course of someone's lifetime?
To the extent that someone does indeed meet diagnostic criteria for bipolar disorder, yes, there certainly can be a waxing or waning or a cyclical pattern of symptoms.
I also want to harken back to the fact that you have done NGI evaluations. Is that correct?
Yes.
And is bipolar a condition that can sometimes contribute to an opinion that someone does meet NGI criteria?
Yes, it certainly can.
And under what circumstances might you expect to see that?
Yes, and so in order to reach an opinion of supporting an NGI plea in the context of bipolar disorder, one, there would need to be a firmly established diagnosis of bipolar disorder, again, in the absence of substance intoxication, and there would need to be a very direct linkage between the symptoms of that mental illness at the time of the alleged offenses and the substantial lack of capacity to either appreciate wrongfulness or to conform conduct to the requirements of the law. It's not enough for the defendant to simply be symptomatic, but that linkage needs to be established with the lack of capacity.
When you talk about establishing that linkage between the crimes alleged and the mental illness that's been assigned to an individual, what sorts of facts or circumstances do you consider when you do NGI evaluations?
And so there would need to be converging data sources indicating that indeed the defendant was symptomatic of that legitimate mental illness at the time, and there would need to be, conceptually, it would need to make sense for the alleged misconduct. There would need to be some sort of reason that mania, for instance, would have caused that behavior. There would need to be evidence to suggest that the person was fundamentally unable to control their behavior. And so again, that would typically comprise a pattern that extends beyond that one momentary act. But it would need to be a broader pattern encompassing that time frame.
So if you are evaluating whether someone's bipolar disorder might be causal of the criminal offenses, would it be significant to you to evaluate the defendant's symptoms or how someone presents immediately before and immediately after the alleged offenses?
Yes, those would be critical time frames in which to gather as much data as possible.
Is that because one would expect that someone with bipolar wouldn't manifest those symptoms solely for a short period of time, but typically over a much longer period?
Yes, that is
Objection
correct.
calls for speculation.
I think it calls for his professional opinion.
Overruled.
Yes, it would be expected to see, again, a symptom duration longer than just the mere moments of committing a criminal offense.
Doctor, I want to quickly return back to some of the other records that had been mentioned. You indicated that you did have an opportunity to review the medical records from Bell and Health from two different stays that Ms. Shabusiness had, one in 2012 and one in 2014.
Yes.
And I'll first call your attention to the 2012 records, if you recall those. Do you remember if Ms. Shabusiness was assigned a diagnosis by the treatment providers at Bell and Health at the outset of her stay in 2012?
She was assigned a diagnosis of mood disorder not otherwise specified.
So she was not assigned a bipolar diagnosis at that time. Is that correct?
Correct.
And then in 2014, did she likewise have some sort of diagnosis following her 3-day stay in Bellin?
She was again assigned a diagnosis of mood disorder not otherwise specified, and they did add, which is not a diagnosis per se, but they noted alongside the diagnosis a history of psychosis. But in looking closer at the records, that history of psychosis derived squarely from an adverse medication reaction, which prompted the initial inpatient stay. So she was prescribed sertraline, and then only after that did she begin to have psychotic symptoms, and those symptoms resolved as soon as that medication was discontinued.
Again, she was not assigned a bipolar diagnosis in 2014 either.
Correct.
Dr. Seipel, you indicated that you did have an opportunity to review Dr. Litton's report from July 3rd of 2023.
Yes, I did.
And what type of report from a forensic standpoint was Dr. Litton's report?
It appeared to be a combined competency and NGI report.
In your experience and training, is it best practice for someone to engage in a combined report of both competency and NGI?
Typically, a separate report would be submitted to address each issue independently.
What are some of the reasons why you might not combine those two reports?
For one, there can be information introduced in the issue of criminal responsibility that might be inappropriate to be contained within a competency report. A competency report is not supposed to contain incriminating information with regard to the alleged offenses. But also, and from a psychological standpoint, it makes it difficult to parse out which data and which arguments are directed at each respective issue if they're addressed alongside each other in the same report.
Is it particularly concerning if you come to a conclusion that a person is not presently competent, that you would also rely on that information to form an NGI opinion?
I would say that it's not inappropriate if that's a data point that is considered, but that there should not be a strong linkage in that reasoning, as again, it's two different legal issues pertaining to two different time points.
Doctor, when you looked at that report as it relates to NGI and Dr. Litton's report, I'm just going to ask you generally, did you have any concerns with the methodology that was shown in that particular report?
I found that it seemed appropriate data sources were consulted, at least that's what the methods section suggested in that report, although there was essentially no discussion or review of the discovery materials that were reviewed, and really no account from a defendant's perspective of the alleged misconduct, which are very critical pieces of information that would always be included in an NGI report.
So those pieces of information that you just discussed, like the account of the offense and the specific discovery materials outlining the offense, why is it important to include that type of information in the report?
Because again, the statute for NGI pertains squarely to the moments of the alleged offense, and that is the data that most directly captures those moments. And so it becomes somewhat of a black box issue if those moments are not discussed in the report and inferences, and instead are appearing to be made based upon presentation at other time points. That's not sound professional reasoning with regard to the issue of NGI.
And I want to talk about information being based on other time points. Did it appear to you that Dr. Litton relied very strongly on her personal observations of Ms. Shabusiness in the interview?
I would say it seemed that the symptoms that were portrayed during the moments of that interview seemed to weigh heavily, as well as the mere fact of a bipolar diagnosis being assigned roughly a year before the alleged offenses.
Were you able to determine whether or not Dr. Litton actually assigned a diagnosis herself?
It seemed implicit in the report that she concurred with the bipolar diagnosis, although it was not explicitly stated. For instance, I am assigning the defendant a diagnosis of bipolar disorder.
Is that typical in your experience to not assign a diagnosis during such an evaluation?
In an NGI evaluation, as the identification of a qualifying mental disease or defect is critical and necessary to support an NGI plea, it would be essential for the diagnosis to be very explicitly indicated.
And that was not done here.
I would say, again, it was not explicit, rather it was more so inferred, being embedded in text.
And Doctor, the report from Dr. Litton, does that include a relatively lengthy or specific discussion of the observations of Dr. Litton from the interview that occurred in June of 2023?
Yes, the greatest detail seemed to pertain to that which would have been her second contact with the defendant.
And you personally had contact with the defendant within about a month of that particular interview. Is that fair?
It would have been roughly like 3 or 4 weeks per my estimation.
The observations that Dr. Litton is making of the defendant, her actions, her behaviors, her psychotic state, did you witness those same things when you met with Ms. Shabusiness?
I did not notice the evident distraction that was evidently apparent during the interview with Dr. Litton. The defendant easily maintained focus and was able to supply coherent, relevant responses to questioning. She remained behaviorally appropriate and was able to engage in detailed discussion of her legal situation. There was a brief moment in which she referenced claiming to see a supposed green train within the room, which is something that was evidently very distracting during the interview with Dr. Lighton. I essentially ignored when that symptom was mentioned, and there was no further mention of it thereafter, and there was no evidence that she was in any way distracted by that or any similar psychotic symptom.
Did you form a conclusion with respect to the psychotic manifestations that Ms. Shabusiness was outwardly claiming to have?
I found that there was not sufficient support for assigning a diagnosis such as bipolar disorder or schizophrenia that could presumably underlie those symptoms.
Did you have any concerns about the validity of the claimed symptoms?
Yes, I did.
And what were those concerns?
And so my concerns were manifold. There has been a remarkable inconsistency in presentation over the pendency of this case in terms of the symptoms the defendant has claimed to forensic examiners versus to clinical providers within the jail. And even during very similar time frames, she's offered contradictory remarks. And apparently, only during the interview with Dr. Lighton has anyone observed her during the pendency of this case to seem to be preoccupied with internal stimuli. That's not something that I have observed, and jail providers have noted that even in the isolated instances where the defendant has endorsed hallucinations, they have viewed no outward indication.
I would object only because that calls for hearsay. I apologize, but
Overruled.
I forgot where you were in your answer, but if you're
another question.
sure. Had other doctors who evaluated the defendant shared concerns that you reported about the possibility of feigning or embellishing symptoms?
Yes.
And who was that?
I noted that first in Dr. Lucetta's competency report, as part of a competency instrument that she administered to the defendant, embedded within that were validity indices. That means there were testing items which sought to determine the credibility of the defendant's endorsement of psychiatric symptoms. And her responses to those items suggested an elevated probability of a non-credible response style with regard to endorsing psychiatric symptoms. And similarly, when Dr. Engen completed her NGI evaluation, she administered the Minnesota Multiphasic Personality Inventory, or MMPI as it's widely known. And the extent of her invalid responses on that instrument made it where her clinical profile could not be interpreted because the validity skills for that instrument suggested she was grossly exaggerating psychiatric symptoms in a manner that would be extreme and inconsistent even for a patient with legitimate schizophrenia.
And did you note whether or not Dr. Lighton performed any such psychological testing to determine the validity of the symptoms that she was observing from Ms. Shabusiness?
I found no mention of any type of instrument for symptom validity within her report.
Was that surprising to you?
I would say yes, in general, but especially specifically given that those psychotic symptoms really seem to be the crux of her opinion regarding the issues of both competency and criminal responsibility, and especially in light of prior testing data that cast significant doubt over the legitimacy of those symptoms. So under those circumstances, it would be extremely unusual for an examiner to not administer testing.
Now, did you administer testing of Ms. Shabusiness when you met with her?
I was prepared to administer testing upon entering the evaluation, although her clinical presentation suggested such testing would not be necessary to reach an opinion regarding her adjudicative competency.
Can you explain that maybe just in a little more layman's details?
Yes, and so to the extent that the defendant would have presented similarly as she did with Dr. Lighton, for instance, presenting herself as very distracted by hallucinations, unable to supply linear or coherent responses, then I would have administered psychological testing to see where the validity lied with such symptoms. Although she did not portray those symptoms and with relative ease was able to discuss her legal situation in a rational manner, so the validity of symptoms became a moot point, that the results of that testing would have had no influence on my opinion regarding competency.
Essentially, you didn't need to test the validity of the symptoms because you didn't see the symptoms.
Correct.
Now, Doctor, you also had an opportunity to review the report of Dr. Engen, which I believe you previously mentioned. Is that right?
Yes.
Now, Dr. Engen's report is a report on NGI and not competency. Is that right?
Yes, it is specifically and solely to the issue of NGI.
Now, some of the shortfalls of Dr. Lighton's report that you already pointed out, did you see those same concerns in the report of Dr. Engen?
I did not.
Can you compare or contrast the methodology that Dr. Engen used to the methodology used by Dr. Lighton?
And so in Dr. Engen's report, I found to be consistent with my training, experience, and my understanding of best practice in the field of forensic psychology, and that she engaged in a thorough review and detailed in her report the discovery materials. She supplied a detailed accounting of the defendant's personal account to her of the index offenses. She reviewed medical records from the Nicolay Psychiatric Treatment Center that, again, would have been in that time period leading up to this offense. And she administered psychological testing to aid in determining the validity of any of the psychiatric symptoms that the defendant claimed during the evaluation. And so that represented to me a full and comprehensive NGI evaluation.
And in contrast, did Dr. Engen's report specifically tie Ms. Shabusiness's behavior at and around the time of the offense to any mental illness or lack thereof?
Dr. Engen supplied a detailed articulation of why she ultimately did not assign a qualifying mental disease or defect diagnosis to the defendant. And then she in turn articulated why she did not believe there was any support for the conclusion that outside of voluntary substance intoxication, the defendant would have substantially lacked capacity to appreciate wrongfulness or conform her conduct to the requirements of the law.
I think we touched on this earlier as it related to general diagnoses of a mental health condition, but can you talk briefly about the impact that acute substance intoxication has on attempting to determine whether or not someone would be NGI?
And so according to the Wisconsin jury instructions, mental disturbance brought on by voluntary substance intoxication is not considered to be a qualifying mental disease or defect. And so to the extent that an examiner cannot rule out the sequelae of that voluntary intoxication as being the primary contributing factor to behavior, then the reason would dictate that an NGI plea cannot be supported.
Thank you, Doctor. No further questions at this time.
Cross-examination, Mr. Freilich.
Thank you, Your Honor. Dr. Seipel, good afternoon.
Good afternoon.
You prepared two reports concerning Taylor Shabusiness, correct?
Yes.
One in November of 2022 and then one in July of 2023, correct?
Yes.
And you received police reports, correct?
I did not review the police reports.
Okay. Did you review the criminal complaint?
Yes.
Did you have a chance to review any video footage from the incident on February 22nd or February 23rd of 2022?
I did not.
In this particular case, did you administer the two gold standard tests, the MMPI and the MCMI?
I did not administer either of those instruments.
Okay. Yet you criticized Dr. Lighton for not doing it, correct?
Yes.
Now, you've been a licensed psychologist since February of 2022, correct?
Yes.
That's when you obtained your license to practice and do evaluations and reports and all of that, correct?
My license enabled me to practice independently, although I performed all of these evaluations under supervision from September 2020 up until that time.
Okay. In September of 2020, that's when you were a fellow?
That's when I began my postdoctoral fellowship in forensic psychology.
Okay. When you've had a chance to review Dr. Lighton's curriculum vitae, correct?
Yes.
You've had a chance to review her evaluation from July 3rd of 2023, correct?
Yes.
As far as experience level, she has more experience than you. Is that fair?
I would say she's been a practicing psychologist longer, although the extent to which she has conducted NGI evaluations, I don't know if she has more experience than me.
You understand that she worked at Mendota Mental Health in the past, correct?
Yes, and typically NGI evaluations are not performed for patients already within the State Mental Health Institute.
Okay. And with regards to Dr. Christina Engen, she works in the Wisconsin Forensic Unit as well?
Yes, she is employed by behavioral consultants in the Wisconsin Forensic Unit.
Would she be a colleague or a coworker of yours?
I would say we are similarly employed, although we practice typically in different areas of the state and have pretty minimal contact with each other.
And the two of you are aligned as far as opinions in this particular case. Is that fair?
Well, we opined on different issues, so I would not agree with that statement.
But the ultimate recommendation is the same, correct?
I guess I'm not sure what you're asking, sir.
That you and her both find insufficient evidence to support the special plea, the NGI plea.
I would say I did not offer an opinion with regard to NGI, so again, I can't agree with that statement.
Okay. You've had a chance to review Brown County Jail records, correct?
Yes,
You reviewed Bell Health records that I sent, correct?
yes,
You had a chance to review the Nicolay Psychiatric Center records through Brown County, correct?
yes,
You reviewed a lot of mental health records, correct?
yes.
Fair to say that Taylor Denise Shabusiness does have a mental health history. Would that be fair?
I would say in general terms, yes, she has had contact with mental health treatment.
And fair to say that she was the subject of a civil commitment in 2021, correct?
Yes, it is my understanding that she became subject to a 6-month civil commitment during the course of her inpatient treatment in 2021.
And she was found by a court of law to be mentally ill, at least in 2021. Is that fair?
According to that court order, it would suggest that, yes.
And then she was on a medication order in order to take psychotropic medications for that same period of time, correct?
Yes, it is my understanding she was court ordered to medication compliance.
A lot of different doctors evaluated and took a look at Ms. Shabusiness, correct?
With respect to the pendency of this case or more generally?
Just with respect to the pendency of this case.
Yes, I would say there have been a handful of us that have completed evaluations.
Dr. Deborah Collins, yes?
Yes,
Dr. Tracy Lucetta,
yes,
Dr. Diane Lighton,
yes,
yourself,
yes,
Dr. Christina Engine.
yes.
With regards to Ms. Shabusiness's treatment at Nicolay Psychiatric Center, was she diagnosed over there in May of 2021 with bipolar disorder, current episode manic severe with psychotic features?
Yes, that was the diagnosis those providers assigned.
She was prescribed medications, correct?
Yes, I believe it was an antipsychotic medication that was prescribed.
Do you know if that was Aristata?
I would have to consult the records to refresh my memory.
Was it your understanding that she was prescribed a medication that would be by injection?
To the extent that it is Abilify Aristana, yes, that is a long-acting injectable medication.
It's an antipsychotic medication, correct?
Yes, with mood stabilizing properties as well.
And fair to say that through Brown County, through Nicolay, that Ms. Shabusiness was given a diagnosis of bipolar disorder.
Yes,
She was at Nicolay for about a month, correct?
I believe it was roughly 3 weeks.
A couple weeks, and then she was discharged.
Yes,
She was discharged, after she had her baby.
what was the question, sir?
Do you know? I'm sorry. Do you know if she was discharged after she had her baby?
I do not believe she gave birth during the course of that hospitalization.
Subsequent to that, she gave birth, correct?
I would again have to consult the records for the dates on that.
When you looked at all these records, did you come to find that there were some references to Ms. Shabusiness suffering from paranoia.
That word was mentioned in the records on some occasions, yes.
And was it mentioned that she had experienced some delusional thoughts?
Again, that was a word that has been used in the records, yes.
And was it mentioned in some of these records that we're talking about that she did suffer from distractions, inability to focus or concentrate?
Yes, there were some notations of those concerns as well.
Was it such that, in gleaning through the records, analyzing them, that she had auditory or visual hallucinations on occasion?
Yes, and most specifically that first admission to Bellin, as well as the admission to the Nicolay Psychiatric Center where I saw the hallucinations mentioned.
Was that mentioned in 2021?
Yes, upon her admission to Nicolay when she had heavily been abusing methamphetamine recently.
You've been a doctor for some time. You've got a PhD. You've got a lot of education. You've had experience with different kinds of patients, correct?
Yes, many, many different kinds.
With all different sorts of problems, correct?
Yes,
And you've dealt with people who have had drug addictions and things of that sort, correct?
yes,
You've gone to seminars with regards to how substances can affect the brain, correct?
yes, and I taught an undergraduate course regarding the effect of substances on psychology as well.
And would it be fair to say that substances can impact the brain, can cause organic brain damage?
I would say there can certainly cause some functional abnormalities in the brain, although the notion that drug use permanently damages the brain really is not consistently bore out in the literature the way that it is in kind of the public conception of drug use.
Drug use can also exacerbate mental health problems, correct?
It can exacerbate them or cause them of their own accord, yes.
What causes memory impairment?
There can be manifold causes for memory impairment.
Drug usage?
Certainly, if there has been recent and especially significant drug use, yes, that can affect various neurocognitive capacities, including memory functioning.
How about traumatic events like loss of a mother?
I would say that can cause some difficulties with concentration, though typically would not cause amnesia in and of itself.
Is PTSD, post-traumatic stress disorder, is that a mental health condition?
Yes, it is.
Can that get worse over time if untreated?
It can, yes.
If someone has a mood disorder, is that a mental health issue?
Yes.
It's a mental defect or a mental disease?
I would say it could meet criteria as a mental disease or defect according to Wisconsin state statutes, yes.
And can that get worse over time, the mood disorder, if it's left untreated?
It can, yes.
People are not subjected to a civil commitment order unless they have a mental health condition, correct? Is that fair?
It would require a clinician to opine that they have a mental illness, yes.
I saw some records in Brown County. I believe it relates to the Nicolay Psychiatric Center records, that there was a problem addressed, risk for self-injury related to delusional thought process vague. Do you know what that references to?
I believe I recall seeing that verbiage in the records, but I wouldn't be able to supply context without reviewing those records.
Do you know if Ms. Shabusiness had problems or issues with a delusional thought process?
At that time, it was noted that that was a symptom she was displaying upon admission to the facility, yes.
Did you have occasion to, when you met with her, to observe that she had a tangential thought disorder?
During my meetings with the defendant,
Yes.
I did not note signs of a clinically significant thought disorder, no.
How about, was that bore out with Dr. Engine or Dr. Collins?
I would say there was, again, no indications of clinically significant impairment in maintaining linear thought during those evaluations.
In your review of the Brown County progress notes from Nicolay Psychiatric Center, did it have references to Ms. Shabusiness identifying demons in her life?
In terms of the Nicolay psychiatric records,
Yes.
I do believe there was mention of some commentary of that sort, yes.
And was there commentary that her affect appeared to be labile and inappropriate throughout group, and that she had mood changes and inappropriate facial expressions or laughing?
Yes, I did see that bore out on those records.
Did you see that when you talked with her in November of 2022 or July of this year?
I did note that there were some moments of some inappropriate grinning or perhaps very brief isolated instances of laughter. All those were short-lived and did not impair capacity for us to have a linear and meaningful discussion.
In July, when you met with her, you said 90 minutes, give or take. Was it cut off for any reason? Was your interview cut off?
No, they were able to be completed on both occasions to their natural course.
In some of the records, did you note that it indicated her affect was flat when approached?
Yes, there were some indications of a relatively flat or diminished expression in her emotional presentation, yes.
What does that stem from, do you know?
That's again something that can have manifold causes and could simply be someone's baseline emotional presentation as well.
Could it be related to a mental health defect or disease?
It is possible, although again, it could also be due to many other factors.
Also in these progress notes, did you indicate, or did you review, excuse me, that she was feeling as though different bodies were going in and out of her person?
I do believe I read that in the Nicolay notes as well, yes.
Did she talk about having pressure in her head or having her head hurt?
Yes, that is a complaint that she has made at different occasions across time, yes.
And did she also indicate that she had problems with eye twitching and that her PTSD was triggered from loud noises?
I do believe I recall seeing those symptoms mentioned in the records as well.
Did you, at least in some of either the jail records or the Brown County records from Nicolay, that she talked about wanting to die and go to heaven to see her mom?
Yes, I do recall seeing such comments made.
And in reviewing these records, because there were a lot of them, did she indicate, at least in the records when she was at Brown County at Nicolay, that she was hearing voices that would get heavier at night?
I do believe, yes, there was a pattern of time of day seeming to impact symptoms at that time, yes.
And the time of day would be more at night, they'd be more pronounced at night than the daytime?
Per my recollection of the records, I do believe that was the pattern that was mentioned.
And she was encouraged to connect with a dual therapist to address mental health and her AODA issues. Is that fair?
Yeah, consistently over time, she has been referred for substance abuse treatment, yes.
And in those records from Nicolay, it also talked about that she would have racing thoughts that would get overwhelmed and that she'd hear voices in her head.
Yes, those are symptoms I do recall seeing in the records.
It's true, right, that there were discussions about her getting this Aristata injection every 4 weeks to help her?
Yes, that is the typical course in which that medication is administered, and per my recollection, I do believe that's what was ultimately prescribed.
Then there was some discussion about whether she would take the pill or take the injection, correct?
Yes, I do believe that the means of administration was discussed amongst her clinical team.
Even in the notes, it talked about, in the notes from Brown County, from Nicolay Psychiatric Center, it talked about how Miss Shabusiness would have agitation, anxiety, correct?
Yes.
And that there was a discussion about giving her Haldol, correct?
Yes, that would be another antipsychotic medication with pretty heavily sedative properties.
Do you know if that was ever given to her?
I would again have to refresh my recollection with the records.
And even in the Nicolay records, it talked about that it was a struggle to decipher what is a genuine psychiatric symptom and what is otherwise talked about as gaminess, correct?
Yes, I do believe that was a term that was employed in the records.
There were just a lot of records to review and you have a good memory. But it also talked about Zoloft, correct?
Yes, that was mentioned specifically in her adolescent treatment records.
And Ms. Shabusiness was given, apparently at Nicolay, from what you reviewed in these notes, what are her coping skills and what does she want to do to make progress with mental health? Is that fair?
I don't recall that specific information.
Okay. With regards to Dr. Lighton, she says that she believes that my client, Ms. Shabusiness, qualifies for the NGI plea based on a diagnosis of a serious mental disorder. You understand that?
Yes, that's what she wrote in her report.
And she opines that her serious mental disorder affected Ms. Shabusiness's ability to know right from wrong at the time of the offense, correct?
I would say it was relatively tersely worded, although that was what was suggested, yes.
And she also said that it affected her ability to control her behaviors. Is that fair?
Yes, that was the opinion that she reached.
You have a diabolically opposed opinion compared to Dr. Lighton, correct?
Again, I did not opine on the NGI issue.
Okay. All right. Thank you. Nothing further.
Redirect.
Just briefly, I think you were asked a great deal again about the records from Nicolay and the specific symptoms that were manifesting at that time at Nicolay. Yeah, do you know if Nicolay actually administered a blood test to determine whether or not there were substances in her system at the time she entered Nicolay?
There was either urine or blood screening performed for toxicology purposes, yes.
And she did test positive for methamphetamine?
It was methamphetamine and I believe also amphetamines and THC as well.
And did the Nicolay records show a marked improvement in her symptoms in the 3-week stay there?
Yes, there was a relatively linear trend over time towards psychiatric stability.
And while that might potentially be attributed to taking psychiatric medications, it might also be attributed to weaning off of the illicit substances.
I would say it's fundamentally impossible to disentangle to what extent precisely the improvement would have derived from those sources.
And you were asked questions about at points in time, did Ms. Shabusiness have potentially paranoia or hallucinations or things that could potentially be associated with psychiatric conditions or psychosis? Did anyone in any of the records that you saw make such an opinion on or around February 22nd and 23rd of 2022?
In terms of those symptoms or diagnoses applying at the time of the alleged misconduct?
Correct.
I would say that from what I saw, Dr. Lighton was the only one that, and again, it wasn't really directly discussed, so at least seemed to imply that those symptoms were at play at the time of the incident.
Now, none of the mental health records that you saw were from February of 2022. Is that correct?
I did not see any indication of her being actively involved in psychiatric treatment, so there was no reliable collateral source to corroborate those symptoms at that time.
And again, just to clarify, I think you've done a good job of this, but you were not asked to opine on the issue of whether or not an NGI offense or an NGI defense is appropriate for Ms. Shabusiness in this case.
That is correct. I was only ordered as a competency examiner.
Thank you. I have no further questions.
On those topics, Mr. Freilich?
No, Your Honor. Thank
Okay,
you, Dr. Slade.
Doctor. You can step down. State's next witness.
State calls Christina Engine.
Doctor, if you just step forward here, and then before you have a seat, if you could turn and face her and raise your right hand, she'll place you under oath.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth in the matter now before the court, so help you God. Yes. Please have a seat and state your name for the record.
Christina Engen, CHRISTINAENGEN.
Mr. Saunders, the witness is yours.
All right, Doctor, how are you employed?
As a psychologist with behavioral consultants,
And how long have you been employed with behavioral consultants?
12 years.
And do you have any degrees?
I do. I have a PhD in counseling psychology from UW-Madison, which I earned in 2010.
And I guess what do you do as a psychologist with behavioral consultants?
I conduct almost exclusively criminal forensic evaluations.
And we've heard that term a few times. What is forensic evaluations? What does that mean?
The court principals will approach a psychologist with a psycho-legal question. So a psychological question that applies to the legal situation, and our job is to help answer that and to provide information to the trier of fact, the judge or the jury, to help them answer that question.
Are some of those evaluations that you're asked to conduct what are referred to as NGI evaluations?
Yes.
And I guess what does NGI refer to?
It's for the plea of not guilty by reason of mental disease or defect. It's an evaluation of criminal responsibility.
And you have performed those evaluations in the past?
Yes.
Are you able to approximate how many NGI evaluations you've completed in your career?
Over the course of 12 years, approximately 250 NGI evaluations.
And are those typically done at the request of a court?
Yes.
Have you, in your career, in those 250 evaluations, reached an opinion that somebody would be appropriate for an NGI plea?
Yes.
And contrary, have you formed the opinion that they are not, they don't fit for the NGI plea?
Yes.
All right. And Doctor, do you maintain a curriculum vitae with respect to your educational background and qualifications?
Yes.
All right. Showing that's been marked exhibit 12. Do you recognize that?
Yes.
And what is that?
It is my curriculum vitae.
And does that appear to be up to date?
Yes,
All right. That's a document that you prepared.
it is.
I'd move 12.
Any objection?
No objection.
12 will be received.
Do you maintain any licensures?
Yes, I'm licensed to practice psychology in the state of Wisconsin.
And are you also board certified?
I am.
What does that mean?
I'm board certified by the American Board of Professional Psychology. Applicants can specialize in several different areas of psychology. My area of specialty is forensic psychology.
And do you maintain any professional memberships?
Yes.
And what are some of those?
with the American Psychological Association and the Wisconsin Psychological Association.
In addition to your employment, do you also, or have you had any teaching experience in this role?
Yes.
All right. What are some of those?
I've provided guest lectures for Marquette Law School, for trainees at Mendota Mental Health Institute, once for the Department of Corrections psychologists.
Doctor, then I want to ask you about this case. Did you become or asked to become involved in an NGI evaluation of Taylor Shabusiness?
Yes.
And how did you become involved in that?
I was court ordered to conduct an NGI evaluation.
Were you retained by the state of Wisconsin?
Appointed by the court.
By the court, but not the district attorney's office?
Correct.
And you weren't retained by the defense either?
Correct.
Is it's the case that most of the evaluations you perform are at the request of the court?
That is correct.
And did you ultimately prepare a report with respect to your findings regarding that NGI evaluation?
Yes.
Doctor, I'm showing you Exhibit 13. Do you recognize that exhibit?
Yes.
And what is that?
It's a copy of my report.
Does that contain your factual findings and ultimately your opinions with respect to the NGI evaluation?
Yes.
I'd move 13.
Any objection? Subject to cross, Your Honor, no objection. 13 will be received.
So I guess generally, can you describe the process that you undergo to conduct an NGI evaluation?
Yes, the evaluation consists of a clinical interview, so a meeting with Ms. Shabusiness. I also conducted a full discovery review, so review of all of the police reports, videos, documents of that. And then I also, in this case, reviewed her available medical records, which included a prior competency evaluation, records generated through Brown County, and then in this case, I did administer psychological testing.
Okay. So I want to first start with the clinical interview that you mentioned conducting. What date was the date that you met with Ms. Shabusiness?
So I attempted to meet with her first on October 12, 2022. However, because of her security status in the jail, I was not able to meet with her confidentially. So I returned on October 21, 2022, and we met in a conference room. That's when I conducted the interview and the psychological testing.
And October 21st, 2022, would that have been about 8 months after the offense that she was charged with?
Yes.
Okay. And you also mentioned you conducted a full discovery review, and that included reviewing videos. Is that right?
Correct.
Okay. Was one of those interviews that you reviewed an interview of Ms. Shabusiness from February 23rd of 2022?
Yes.
Was that a rather lengthy interview?
It was.
Did you review the entirety of it?
To the best of my recollection, I believe that I reviewed the vast majority of it. If I would say the majority of it.
All right. Were there a lot of dead parts in the middle of it?
There were, but I thought it was important to review that video footage to listen for comments that Ms. Shabusiness would have made in the room by herself to observe her behaviors and the like.
So it wasn't just the comments that were made to law enforcement that you were looking for, but also her independent behaviors?
Correct.
And you also mentioned you reviewed the police reports and other various attachments that were part of the case?
Yes.
The medical records that you reviewed, you mentioned there were prior competency evaluations, but also Brown County Health Services records. Is that right?
Correct.
Was that in reference to a stay at Nicolay Psychiatric?
Correct.
All right. And when was that?
That spanned March of 2021 to April 2021.
All right. And You then indicated you also conducted a, I guess, personality test, or what was the fourth collateral source you reviewed?
I can administer an objective personality test. It's called the Minnesota Multiphasic Personality Inventory, third edition. The acronym is MMPI-3.
So I want to then go through your report, if that's okay, Doctor. Beginning on page 2. So one of the things you start with is called relevant history. Do you see that section of the report?
Yes.
And I guess why is it important to review the history as part of your NGI evaluation?
When gathering history about a defendant, we are touching on topics that are potentially relevant to the issue of criminal responsibility. Things like early childhood events, history of mental health treatment, substance use, any learning difficulties, difficulty working, all of this can potentially inform the issue of criminal responsibility.
Okay. And as part of that, did you review Ms. Shabusiness's employment history?
Yes.
And I guess what did you note with respect to her employment history?
What I recall is that she has worked primarily in factory settings. Relevant to this evaluation was that she was working up until about a week before the underlying offenses.
Why is one's employment history relevant to an NGI evaluation?
It speaks to the prong of behavioral control. So later on, when we discuss the prongs of the NGI plea, one of them has to do with one's ability to conform their behavior with the requirements of the law. It's a capacity issue. So can a person do that under normal circumstances? And one's ability to work, maintain employment, show up, perform their job duties, that speaks to an individual's capacity to conform their behavior and meet the demands of daily living.
Okay. And you noted employment history fairly consistently up to about, I think you said a week before the offense?
Correct.
And you also reviewed Ms. Shabusiness's mental health history as well?
Yes.
As we talked about. As well, did you review her during the course of your clinical interview with Ms. Shabusiness, her current presentation?
Yes.
And I guess what is the importance of kind of noting as you do the current clinical presentation of a patient?
So that's another piece of information that informs the diagnosis that is required of the evaluation.
Okay. As part of the clinical interview with Ms. Shabusiness, do you get a narrative from her about the alleged offense?
To the extent that I was able, I did. Ms. Shabusiness recalled the time period leading up to the offenses, but then she reported that she had no memory for the offenses themselves, and she reported she did not regain memory until after her arrest.
Okay. With respect to Ms. Shabusiness recalling the time period leading up to the offense, what sort of information did she provide?
What I learned was that she had been living in Texas and returned to Wisconsin in early 2022 to tend to legal matters. She made a court appearance. I believe she was sentenced to 5 years probation. She was making arrangements to have her community supervision transferred to Texas so that she could resume caring for her newborn baby, who was in the care of her grandparents. She was working. She had started Suboxone treatment to maintain sobriety. And I understand that she struggled during this time period, was feeling what sounded like to me some alienation in the workplace. Not feeling like she was connecting with her coworkers, and then began to, she reported to me she was hearing voices that were telling her to relapse on methamphetamine.
Okay. And some of those you mentioned, employment, you mentioned some arrangements with respect to childcare. Why are some of those acts kind of relevant from an NGI evaluation standpoint?
Again, it speaks to the issue of one's capacity to conform their behavior. So all of those are very goal-directed tasks.
And those were all kind of leading up to the date of the offense.
Correct.
With respect to February 21st, 2022 specifically, did she have a narrative about sort of the timeline of events leading up to the offense?
Yes, on February 21st, 2022, she recalled that she was socializing with friends. They had come to the residence she was staying in. I believe they were smoking marijuana. She expressed an interest in finding methamphetamine, and so she said that she went on a quote meth hunt, end quote.
Did she indicate whether she had ingested methamphetamine leading up to the homicide?
Yes, she told me that she took 52 hits of methamphetamine.
Did she also refer to that amount as, quote, a lot?
Yes.
All right. And did she indicate at some point that night meeting up with the crime victim, Mr. Therian?
Yes.
And then you indicated around the time of the alleged offense, she reported having no memory of that time.
Correct.
Did she, and then you indicated she regained her memory sort of in speaking with law enforcement.
Yes.
Was that professed amnesia of a concern to you?
It was notable. As I indicated in my report, I found her self-reported amnesia to be inconsistent with my review of the discovery material. So specifically, I observed her describe in great detail to the detective the details of that evening. So that stands in contrast to her self-reported amnesia in the present or at the time of the interview.
You also indicated during interview with Ms. Shabusiness, you performed some psychological testing. Is that right?
Yes.
What testing did you administer?
It was the MMPI-3.
What is the MMPI-3?
It's a very well-established psychological instrument dating back to the 1940s, very well researched and respected. So this test can provide indication of different types of psychopathology or different types of mental illness. It also contains a number of validity indices to help psychologists understand the response style of the test taker.
So the validity indices, I think I said that right, that you mentioned, I guess, what does that mean?
What that means is that built into the test are several items that when they're all combined at the end, they'll indicate if a person is answering questions in a forthright manner, if they're minimizing their symptoms, or potentially if they're exaggerating their symptoms.
So is this test like a true-false questions, or how does this test administered?
Correct. It's a true-false instrument.
And I guess what were some of your findings with respect to Ms. Shabusiness's performance on the MMPI test?
Well, first, let me be clear that the test does not say anything about Ms. Shabusiness's functioning. In February of 2022, it only provides information about her functioning at the time of the test. So what was relevant from that was that there was indication of symptom exaggeration. She responded to items, she endorsed a number of symptoms that genuine individuals with genuine mental illness would not endorse. The frequency, number of unusual symptoms that she acknowledged was greater than those with genuine mental illness. And then there was also indication of non-credible memory impairment built into those, the results of those validity indices.
So I just want to go back a little bit. And that was a good point. So this testing is sort of in the moment as you're meeting with Ms. Shabusiness. Is that right?
Correct.
But why is it still something you administer in the course of an NGI evaluation?
So getting back to that term of response style, that's very important to understand if the individual is being forthright in their account of information that they provide to me. And what I found with these elevated indices indicating the exaggerated descriptions of mental illness, unusual descriptions of mental illness, is that the information that was being reported to me needed to be interpreted with caution. Ms. Shabusiness's self-report could not be taken at face value.
And I think you state that anything that's not objectively observed should be closely scrutinized. Is that right?
Correct. So then it would be important to find other sources of information that would support what she's telling me versus relying just exclusively on her self-report.
And one of the phrases you used was endorsed symptoms. What does that mean?
For example, I'm just making this test example up, but I feel depressed. A true response would be an endorsement of that symptom.
So an endorsement is something somebody's telling you.
Yes.
All right. So based on the interview you had with Ms. Shabusiness, your review of some of those collateral sources of information, were you able to offer an opinion with respect to whether Ms. Shabusiness was suffering from a mental disease or defect?
Yes.
And what was, I guess, that opinion?
I reached the opinion that while she did have a mental health conditions, these did not appear to qualify as mental diseases and defects.
In your report, you outlined, I guess, 3 mental health conditions. Is that right?
Correct.
What are those?
The diagnoses that I offered were methamphetamine-related use disorder, and that was applied in acknowledgement of Ms. Shabusiness's general use of methamphetamine in that time period. The diagnosis of methamphetamine intoxication was applied because she was using methamphetamine at the time of the crime. And then the final diagnosis I gave was methamphetamine-induced psychotic disorder. And I offered that one because Ms. Shabusiness was describing, and the records contained indication of paranoia. I think she made a comment about muscle rebuilding during the homicide, and this indicated to me the presence of psychotic symptoms, which I attributed to the recent methamphetamine use.
So, and that's a question I have. So mental health conditions, in your opinion, are different from mental diseases or defect?
Correct.
And the 3 diagnoses you offered, you stated those are not mental diseases or defects.
That is my understanding.
And why is that?
Because, excuse me. So if one ingests an intoxicant voluntarily, so they took it of their own volition, and if they were not naive to its effects, that would mean it's my understanding based on the case law that the defendant would be subsequently responsible for all alterations of thinking, judgment, behavior related to that intoxication.
I guess, were you aware of any information in the materials you reviewed that Ms. Shabusiness's methamphetamine use was anything but voluntary?
No.
And that obviously she reported a history of using methamphetamine to you?
Yes.
So I guess, were you of the opinion that she was not naive to its effect?
Correct. Yes. And I'm also aware that she had psychotic symptoms in the context of methamphetamine use the year prior. So certainly she was aware of its effects, broadly speaking, to include psychosis.
So I want to pause just here. Methamphetamine use in general, I guess, in your experience and in your education training, are you aware of some of the symptoms that may manifest as a result of that?
Yes.
And what are some of those?
Excessive energy, decreased need for sleep, and then oftentimes we see in the field of forensic psychology that it can induce psychotic symptoms. So misperceptions of reality and paranoia.
You also mentioned a year prior there was a diagnosis of at the Nicolay Psychiatric Center. Is that right?
Yes,
And did you consider, I guess, the applicability or the appropriateness of a bipolar 1 disorder?
I did.
And what was your conclusion with respect to that propriety of that diagnosis?
After considering the diagnosis of bipolar 1 disorder, I did rule it out because I am aware that being intoxicated or having a methamphetamine-induced psychosis can look virtually similar or indistinguishable from a manic episode with psychosis. So the two look similar. And so what I would be looking for if I were to support a bipolar 1 disorder diagnosis is the presence of that psychosis and the mood elevation when there's no methamphetamine use present.
And are you aware of any of those symptoms absent in the context of methamphetamine use?
I am not aware of a time ever that Ms. Shabusiness displayed psychotic symptoms or elevated mood outside of the methamphetamine use.
And I guess you are aware, though, that bipolar 1 diagnosis was applied to Ms. Shabusiness in April of 2021.
Yes.
Are you aware, though, that there was concerns about recent methamphetamine use around that same time?
Yes, I believe that she tested positive for several drugs, including methamphetamine at that time.
So that's why that's not a diagnosis you are willing to give to Ms. Shabusiness.
Objection leading.
Just clarifying the testimony. I'm just clarifying the testimony.
Overruled.
Thank you. So I guess in sum then, is there any mental disease or defect that you would diagnose Ms. Shabusiness with?
Yes, also offered at Nicolay or Nicolette, I'm not sure the pronunciation. There was a diagnosis of, I believe it was polysubstance abuse or something to that effect, meaning multiple substances were being abused at that time. I believe that's an appropriate diagnosis for her. I do believe that, I believe firmly in the diagnoses that I offered in my report.
Okay. But those are not diagnoses that I guess are mental diseases or defect.
Correct.
Okay. Did you also then reach an opinion with respect to the, I guess, second question or the second part of the NGI evaluation, whether she was responsible for the conduct?
Yes.
Okay. And what was that opinion?
I found insufficient support for the conclusion that as a result of a mental disease or defect that she either A, was unable to conform her behavior to the requirements of the law, or B, was unable to appreciate the wrongfulness of her conduct.
What are some of the reasons you reached that conclusion?
Well, first, and most importantly, I was not able to find support for a diagnosis that would qualify as a mental disease or defect. So really at that point, then the analysis could end. That's a requirement of the plea. But I found in my report, I outlined various different factors, but focusing on the two issues, one's ability to conform their behavior to the requirements of the law and one's ability to appreciate wrongfulness. First of all, I did pull from her behavior outside of the moments of her known intoxication to observe that she was able to engage in very goal-directed behavior. So I assumed that any alterations in her behavioral control were directly related to the methamphetamine use. So that was the first issue. And the second issue having to do with wrongfulness, it was my opinion that she did demonstrate appreciation of wrongfulness. There were several comments that were made to law enforcement, expressing apologies to the victim's sister, indication that she was trying to conceal the body was dismembered because she wanted to conceal it. These all speak to awareness of consequences, appreciation of wrongfulness, that she grasped wrongdoing had occurred.
And did you also consider, I guess, the validity of the professed amnesia for the time surrounding the offense?
Yes, I did not find the self-reported amnesia to be credible. First of all, there was that disconnect between what she was reporting to me in the interview as compared to the recollection she had during an interview with the detective immediately thereafter. And then I also found indication in the results of the MMPI-3 that she was not, that she was reporting on credible memory impairment.
Do you have just a few more questions, Doctor? Your report was done in November of 2022, is that right?
Yes.
And subsequent to that time, have you had the chance to review any other NGI evaluations conducted in this case?
Yes.
And who authored those reports?
Diane Litton.
Okay. And in your review of Dr. Litton's report, did any of her findings or conclusions alter your opinion from November of 2022?
No,
I guess the same opinions you're testifying here to today?
it did not alter my opinion.
And then all of the opinions that you're offering here today, are they to a reasonable degree of professional certainty?
Yes.
Thank you, Doctor. Nothing further, Your Honor.
Cross-examination, Mr. Freilich.
Would we be able to take a break right now or not?
Okay. Ladies and gentlemen, we'll take a 10-minute break and we'll resume. All rise for the jury. And Doctor, you can step down. All right. We'll be recessed then for 10 minutes. I'd like the attorneys to return. Obviously, 10 minutes is a little bit before 3. I'd like to hear a little bit before 3 so I can speak to you a little bit about these instructions. Okay? So we're in recess. Thank you. And we'll resume. All rise for the jury. Okay, before we bring the jury out, just briefly, I've had distributed to you a set of instructions and a proposed instructions and a proposed set of outline as to how they should be given. There's certainly other instructions that could be given that were given to the jury the first time regarding objections of counsel, improper questions, things of that nature. Although they've gotten all those instructions already, I'm not sure the need to do that. But I'm going to start with the state. Mr. Saunders, do you have any feedback regarding the proposed instructions I laid out, alternative suggestions?
No, and I have no additions. I'm fine with the ones the court selected. I guess our one quibble, our preference would be to do the instructions then closing, but that's the only change the state would have.
Mr. Freilich?
Your Honor, I agree with that. I'd ask that the court give the jury the instructions and then we can do the closings. When I look at 605B on question 1, it talks about at the time the crime was committed, did the defendant have a mental disease or defect? But then in question 2, it says, it uses the word mental disease or defect as well. I'm wondering if the court would consider mental disease or mental defect. Because it's either a mental disease or a mental defect.
Sure. I'd certainly consider that. The other thing is you'll note, and I'll consider the issue that you've mentioned regarding when I give the instructions. And I want to just a brief conversation about that, but we can take that up when evidence is concluded. I gave you 605B. It was actually 605B, the version with the comments, because of the paragraph on the second page of 605B, the comment about the possibility of using the phrasing mental disease and defect, and then it's cited the case. I don't think that's appropriate to use and in this case, given how the evidence comes in. That case that cites phrasing it mental disease and defect apparently was in a situation wherein the assertion was that there was a combination that went into the events. A mental disease and defect were co-occurring, and so counsel asked that the word be changed. I don't think that's what's going on in this case. The evidence seems to come in this case that either there is a mental disease or a mental defect, and there's one or the other, and the jury can look at it and decide. They can choose either one. But it's not a case where we're driving at a specific argument that there's a combination of the two and therefore changing the word to and. Nonetheless, I wanted to call it to your attention. I don't have any problem with your request, Mr. Freilich, to change that question 2 to as a result of the mental disease or mental defect. Any problem with that, Mr. Saunders?
No.
Any concern with leaving it as an or, Mr. Freilich, versus an and?
I've always thought that it was an or, Your Honor.
And that's the pattern instruction. I only provided that one case note to indicate that there is a situation in which it was changed to and that's permissible. I don't think it's appropriate for how the evidence is coming in this case, but I'm going to leave it as or. You're not asking for anything else. You don't have any objection to or, do you, Mr. Saunders?
No.
Okay. Very good. I'll add that one word in, and then we'll discuss the order of the instructions versus your closings at the conclusion of the evidence, and we'll actually have an official instruction conference at that time. Okay, then anything else before the jury comes in, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right. Doctor, if you want to step forward. Okay, be seated. All right. Then we're back on the record, and we're up for cross-examination. Mr. Freilich, do you have cross-examination?
Yes, I do, Your Honor. Thank you very much. Dr. Engine, good afternoon.
Hello.
So you work for Behavioral Consultants, is that correct?
Yes.
That's in Milwaukee.
Yes.
Is that part of the Wisconsin Forensic Unit?
Wisconsin Forensic Unit is a division of behavioral consultants.
And with regards to this case, you did not do a competency evaluation. You did an NGI evaluation.
Correct.
You met with Taylor Shabusiness, correct?
Yes,
You recognize her here?
I do.
And ma'am, you met with her at the Brown County Jail on October 12th and October 21st of 2022?
Yes.
Have you met with her since?
No.
So it's been, is it fair to say that it's been about 9 months since you've seen her, correct?
Yes.
The first time that you tried to see her, there was some sort of a security issue going on and you were not allowed to see her, is that correct?
I was allowed to see her, but only cell side, and I thought that would be inappropriate to conduct an interview cell side.
As far as the things that you did to, put your report together, you relied on the 2 clinical contacts on October 12th and October 21st of 2022, correct?
Yes.
You administered the MMPI, the Minnesota Multiphasic Personality Inventory 3, correct?
Yes.
I see that number changes oftentimes. Has it changed?
It actually, I can't recall how long it was the MMPI-2, but it was that edition for several decades. And the MMPI-3 was based on 2017 population estimate. So it's a relatively recent addition.
And it gets updated and upgraded every few years. Is that fair?
No, it was many decades before it was updated.
Okay. And it's essentially a true false test?
That's the response format. It's more complicated than that.
Okay. What kind of questions are on this MMPI?
So I provided, an example that I made up, but there's various statements, and the respondent is asked to respond true or false if they agree or mostly agree with the statement, or disagree or mostly disagree with the statement.
Strongly disagree?
I can't recall the test instructions, but something to that effect.
Do people that have, education issues or lack of education, do they struggle with the MMPI?
There is a reading level that's required to administer the MMPI. I don't recall it off the top of my head.
How many questions are on the MMPI?
About 335.
Okay. How long does it take to get through the test?
In the case of Ms. Shabusiness, I believe it was completed within about 90 minutes, maybe an hour and 45 minutes.
Sometimes longer if you have difficulty reading?
Could be.
So that was done. You reviewed some police reports in this case?
Yes.
A criminal complaint and some video footage, is that fair?
Yes.
Photographs?
Yes.
How did you get that information?
It was provided as part of the entire file. That's standard. It comes along when we receive a referral for an NGI evaluation.
Was it sent to you by the district attorney's office?
My office would have taken care of that. I received it from my office.
Okay. And then you looked up some information on CCAP, the Circuit Court Access Program?
Yes. Basically
a search on the internet of her background?
Correct.
Specifically her prior record?
Yes.
And then you looked at some Brown County Human Services records?
Yes.
Would that be the Nicolay Psychiatric Center records?
Yes.
Okay. So you looked at those?
Yes.
And then you looked at some jail records?
I did not, I requested the jail records, but they had not been received.
And was there a request to see some Purveya health records?
Yes,
Did you get to see those?
no,
Did you review any Bellin health records?
no.
Was it your understanding that Taylor Shabusiness had some treatment stays at Bellin Health in the past?
Yes, I understood that she attempted suicide at age 14, resulting in the admission to Bellin.
And what about at Purveya? Was it your understanding that she had gone there for some mental health treatment as well?
Yes, outpatient treatment.
So you were missing the Bellin records and the Purveya records, correct?
Correct.
Now, you got some relevant history, some background information about my client, correct?
Yes,
You found out that she was born in Chicago, correct?
yes,
She was raised in Lindenhurst, Illinois. Is that fair?
yes,
And then she moved to Green Bay in 2009 at maybe age 11.
yes,
And that same year, her mother passed away.
yes.
Was it your understanding that her mother died in the house when she was there?
I don't know those details.
Was it your understanding then that she was raised by her father, Arturo Coronado?
Yes,
And then did she also relate to you that she moved to Cotulla, Texas when she was 16 to live with her grandparents?
yes,
And that she had a series of moves. She lived in Cotulla and Alice, Texas, and Jackson, Mississippi,
yes,
then came back to Green Bay.
yes,
That's kind of the progression. Is that fair?
correct.
You found out that she was also married in February of 2020.
Yes,
And when you were involved, had she given birth to her child?
yes, that was October 2021.
Ultimately, the child went to live with the grandparents, correct?
Yes,
In Texas.
yes,
Did you garner information that she was in an abusive marriage with her husband?
what I gathered was that she was married. There was discord within the marital relationship, which led Ms. Shabusiness to rekindle her friendship and romance with the victim in this case, and that would have been in 2020. I can't speculate beyond that, the
did you-
nature of the relationship.
Did you get any information that her husband was hitting her in the head?
Objection
No.
asked and answered. Which is a no.
No, that's a different question.
Overruled.
No,
Okay. So you got some background regarding her life, correct?
yes,
Did you find out that she went to middle school in Green Bay and went to Bayport High School as well?
I don't recall that specific detail. I know that she graduated high school in Texas.
As part of the educational, assessment, as part of your report, did she report a history of some learning disabilities or difficulties?
She did. She attributed them to a diagnosis of attention deficit hyperactivity disorder.
And was it such that she had some issues with school, suspensions, ultimate expulsion?
Yes, she was expelled, the result of fighting.
The information that you have as far as your November 14th, 2022 report, it's somewhat stale. Is that fair?
I would disagree with that.
It is from last year though, correct?
Correct.
Nobody gave you any reports from Bellin Health to review, correct?
Correct.
You could have, doctor, upgraded your report by looking at additional records, Bellin Health and the Purveyor records. Is that fair?
Where I left my report, as indicated on the last page, is that I would be happy to receive any additional records that I was unable to obtain. And I would update my report once received if it changed my opinion. I received no additional records after submission of this report.
Your colleague in the field is Dr. Matthew Seipel, correct?
Yes.
And did you confer with him with regards to, your opinions, your assessment, your evaluation?
No.
Did you share any information with him?
I did provide him a copy of my records that I obtained from Brown County at his request, and that's a common practice among evaluators.
Sure. But fair to say that he didn't reciprocate by sending you the Bellin Health records that he had?
No, he did not.
Okay. That is something that could have been done, correct?
If I was not alerted that those were part of our practice, I wouldn't have known to request those. And it's not clear to me that Dr. Seipel would know that I was looking for those. Typically, what will happen is that I will receive additional records from one of the court principals with an indication that they would like a second review of the issue.
Does it surprise you that, as far as Dr. Seipel is concerned, I provided the Bellin Health records to him for his evaluation and that he didn't send them to you?
Can you repeat the question, please?
Does it surprise you that, I sent the Bellin Health records to Dr. Seipel and he didn't send them to you?
That would not surprise me because unless he had instruction to provide them to me, that would not be common practice.
You don't share information then, correct?
Only upon request, if it's appropriate, if it would be appropriate and permissible and specifically requested, but we don't, as a general practice, pass records between doctors.
If you had received these records, you could have done a supplemental report. Is that fair?
If it changed my opinion, if I felt that it was relevant and added meaningfully to this evaluation, I would have, yes.
Now, as it relates to the Nicolay Psychiatric Center, you had a chance to look at all those records, correct?
Yes.
And was it your understanding that Taylor Shabusiness was committed and she was sent to that facility for, mental health treatment, correct?
Yes.
And you were aware, tell me if you were you aware of an order for civil commitment for her?
I was not.
Had you ever been made aware that she was under an order to take psychotropic medications?
No.
If I told you that she was civilly committed in April of 2021, where a court of law determined that she was mentally ill, would that cause you to have any concerns?
It would certainly be relevant, but it does fit with the information I already had that Ms. Shabusiness was discharged from that facility to outpatient treatment with the goal of receiving substance use treatment.
And did you know when she was at the Nicolay Psychiatric Center that she was under an order to take medication?
No.
Did you know that she was required to take antipsychotic medication?
Yes, I was aware that she was prescribed Abilify, an antipsychotic.
Injectable antipsychotic?
Initially oral, later injectable.
Now, during your two contacts with her in October of 2022. Did you get a sense that she was suffering from any kind of auditory or other hallucinations?
She reported that to me, but her behavioral presentation to me was inconsistent with her self-report. And the quality of her self-report was not consistent with genuine psychosis.
Did you gain any information that she was suffering?
Her emotional expression was odd when I met with her, but I would, she did not present as acutely depressed or hypomanic, let alone manic. So I wasn't seeing significant indication of a major mood disorder.
You did see in the Nicolay records that there was a diagnosis for her of bipolar 1, correct?
Yes.
With psychotic features, is that correct?
I don't recall that qualifier, but certainly the record does indicate that she was experiencing psychotic symptoms at that time.
And that is a qualifiable mental disease or mental defect, correct?
Yes.
Do you agree that if someone has an underlying mental health disorder, that using or abusing drugs can exacerbate that mental health disease or defect or condition?
I would agree with that statement.
Did you notice that Ms. Shabusiness was a poor historian when you asked her questions and asked her to expound on whatever topics of discussion?
Where I found that she provided a sufficiently detailed history. Where she was lacking was when I asked her to describe her recollection of the underlying offenses.
Did you note her to have memory loss or memory impairment?
I did not, aside from that self-reported amnesia, I did not detect memory loss.
How much time did you spend with her on October 12th of 2022? Do you know?
I would estimate about 15 minutes.
15?
Yes.
Okay. And then, doctor, on October 21st, 2022, how much time did you spend with her then?
I can't recall. My best estimate would be about 3 hours, but again, that's 9 months old.
Long time ago, right?
9 months, yes.
Okay. Do you agree that methamphetamine use does cause brain damage?
It does have that potential.
And how about adolescent long-term marijuana use? Same thing?
I'm less certain about that.
Certainly, if you're using heroin or cocaine or drugs like that, that can cause brain damage as well.
Yes.
When you met with her, you did find that she exhibited some psychotic symptoms. Is that fair?
No.
In some of the records that you reviewed through Nicolay, did you recall reading anything about a recommendation for her to be on Haldol?
No. And then to be clear with your last question, I did not personally observe psychotic symptoms during the moments of my evaluation of Ms. Shabusiness, but I did see in the record indication of past psychotic symptoms, to be clear.
Okay, yeah, thank you. Did you see in the records there was a recommendation for her to be on Haldol?
No, I don't recall that.
You were asked to opine on the NGI issue, correct?
Yes.
Dr. Seipel was asked to opine on the competency issue, correct?
That is correct.
We're not talking about competency, we're talking about NGI. Is that fair?
Yes.
You had a chance to review Dr. Layton's report. Is that fair?
Yes.
You read through the entire report and you're familiar with Dr. Layton's opinions, correct?
Yes.
And do you agree with her findings?
No.
You would agree that Dr. Layton's report is more current than yours. Is that fair?
Well, it was authored more recently, but the authoring of the report has little to do with its relevancy because we were both doing an evaluation that was retrospective. So if you're looking at it, my evaluation would be more current than Dr. Layton's because mine was in closer proximity to the alleged offenses. So that's another way to look at it.
But another way to look at it is your, with due respect, your report is lacking because you haven't reviewed the Bell and Health records, correct?
It is missing that piece of information, but I would like to point out that it's not common for me as an evaluator when I'm looking at an offense that occurred in 2022 to be requesting records from when one was a teenager. Those would not be, they're certainly generally relevant, but they say little about what was going on in 2022.
Did Taylor Shabusiness tell you that she had no memory of the alleged offense? Did she tell you? When did she tell you that on both dates? October 12th and October 21st?
I did not ask her about the offenses on the first date. I only asked her on the second date, which is when she reported the amnesia.
That was on October 21st of 2022.
Yes.
And in reviewing those Nick Lay records, it's true that she was hospitalized, correct?
Yes.
For about a month, right?
A
couple weeks.
Somewhere between a couple of weeks and a month.
Okay. And that she was prescribed some medication for nightmares?
I believe that she was prescribed Abilify.
And
I can
go ahead.
refresh my recollection.
Page 3.
Thank you. Okay, sure. She did say Prazosin for nightmares.
Okay. And it was such that when you talked with Taylor Shabusiness that she was actively hearing voices, those were the comments that she made to you?
Yes.
Did she indicate to you that she was hearing voices, in her cell?
Yes.
Who were they of?
I think she was less clear. They were very vague. She may have suggested that she was hearing voices of her coworkers, pejorative in nature. She also said that she was hearing a voice saying, "I love you." I don't know who she said was saying, "I love you."
Can you help me with this? What is a manic symptom?
That would be extreme mood elevation, increased goal-directed activity, decreased need for sleep, decreased risk appraisal. Those are some primary characteristics.
Extreme mood, like throwing a chair at a doctor?
What I gather that you're referring to is the evaluation of Dr. Layton of
Yes.
Ms. Shabusiness. I'm hesitant to characterize that as a product of a manic episode.
As far as you understand, it happened out of the blue, correct?
Yes.
Did you have the occasion to review the report from Dr. Tracy Lucetta?
No.
This is a yes or no. You could have gone back to see Ms. Shabusiness after October 21st of 2022. Is that correct?
If you're looking for a yes or no answer, I'm not able to answer that in a yes or no fashion.
The fact is you didn't, correct?
That is correct.
Did you see, when you met with her in October, did you see her use odd or unusual facial expressions?
Yes, I believe there were instances of her smiling inappropriately.
It didn't track or it didn't follow, correct? It was out of context. Is that fair?
Yes.
Okay, I have nothing further. Thank you.
Redirect, Mr. Saunders.
Doctor, I want to pick up on questions towards the end there. You were asked to describe what a manic episode or manic symptoms are. Is that right?
Yes.
With respect to a bipolar 1 diagnosis, one of the requirements is a manic episode, right?
Yes.
And how long do those typically last?
They can last for quite a long time. And then that would be, based on my experience, that they can last as long as months, oftentimes until treatment is administered.
The diagnostic criteria sort of requires there to be a week of manic episode. Is that fair?
I would need to look at the DSM, but that would make sense.
All right. So you said that you were hesitant to say the instance of chair throwing was a manic episode. Is that what you said?
Yes.
And can you explain why?
There are many reasons for a person to throw a chair. One of them could be due to a manic episode. But before I would make that conclusion, I would want to have compelling evidence that such a diagnosis is appropriate. And that would need to include objective evidence, meaning observation over time when a person is not being thinking that they're being viewed, things of that nature.
So I guess then would some of that objective evidence be to consider time periods both before and subsequent to the manic episode that you're observing?
Yes.
Why would that be helpful to know?
It would speak to consistency of behavior. There's a lot of information that can be gathered by looking at behavior over time. When is the onset? Does it happen? I mentioned this earlier. Does it happen when people are not being, when they do not know that they're being observed, things like that. And then there's more, the more objective evidence there is, the more credible that diagnosis can be.
So I guess in general, if you're attempting to determine whether somebody is actively having a legitimate manic episode, you sort of look at the time frame both before and after.
Yes.
You were asked some questions about your interactions with Ms. Shabusiness, about her reporting or endorsing that she was hearing voices. Do you remember those questions?
Yes.
And you indicated sort of her response to those were sort of vague in terms of what she was experiencing.
Correct.
In your opinion, did that appear to be consistent with genuine psychosis?
No.
Why is that?
To me, my take on them was that they were represented some social anxiety, some rumination, her thinking about her circumstances. They seemed like more of an internal dialogue versus an actual auditory hallucination, which can tend to be more bizarre. You also will see behavioral indication that a person is responding to internal stimuli or the auditory hallucination. So you'll see indication, maybe the person won't even say that they are experiencing these voices, but they'll be distracted, have a difficult time completing their thoughts. It's a lot more subtle of an expression than simply saying, I'm hearing voices.
And none of the sort of other things you are trained to look for, you observed in Mission Business?
Correct.
And in addition, you've already testified to concerns about exaggerating of symptoms.
Yes.
You were asked questions about review of certain records, particularly the Bellin Health records. You were aware that there was a prior attempt of self-harm previous in Mr. Business's history?
Yes, at age 14.
Okay. And records from that age, 10 years or so from prior to the date of the offense that you're attempting to determine here, do you believe anything in those records would substantially change the opinions you're testifying here to today?
As I know it, there's not anything that would speak specifically to the issue of the NGI plea. But as I indicated, I would have been happy to receive those records if they had been made available to me. I felt, though, that for me, one of the main issues was Ms. Shabusiness's use of methamphetamine at the time of these offenses. And I don't think that information generated 10 years prior would change that. So, in sum, no, I do not believe those records would change my opinion.
Okay. And then I'll sort of pick up on the methamphetamine you brought up because you were asked some questions about that, about psychotic symptoms that you had observed in Mission Business's records in the past. Is that fair?
Yes.
And are you aware of any of those symptoms that were reported absent the context of methamphetamine use?
No, I am not.
And so like concepts like, psychosis or meth-induced psychosis, I think you mentioned, those are as a result of methamphetamine use.
Yes, my review of the record indicates that all of the psychosis observed objectively occurred in the context of methamphetamine use.
And then finally, you were asked some questions about the MMPI. I think there was a question about like lack of education and if that can impact that. Is that you remember that question?
Yes.
All right. Is there any information you're aware of any cognitive deficit for the defendant?
No, my understanding was that she attributed her learning difficulties to ADHD. She did not have an individual education program or IEP that would signify learning deficits, and she has a high school diploma, which indicates she had sufficient reading level to take the MMPI 3.
Thank you, doctor. Nothing further.
Anything on those topics, Mr. Fraley?
Did she say that she had concentration issues?
I don't recall that.
When you talked to her, she was very quiet, correct?
She was soft-spoken.
Didn't give a lot of information, correct?
I disagree with that. I obtained a reasonable history from her.
Okay. It wasn't like she gave one-word answers,
No,
but the responses were short. Is that fair?
no.
Okay. Nothing further.
Anything on that?
No.
Thank you, Dr. You can step away.
Thank you. Any other witnesses from the state? No, Your Honor, the state rests.
Any rebuttal testimony, Mr. Freilich?
No.
Okay. Ladies and gentlemen of the jury, the evidentiary portion of this case is now closed. So to give you a sense of what's next, it's similar to the process that you've already experienced, and that is I'm going to instruct you as to the rules of the law that you need to apply. The attorneys will make their closing arguments, and then you'll deliberate. I need a few minutes to work with the attorneys. The instructions are much shorter this time, so I won't need as much time to work with them on it. But I do need a few minutes to finish those up, so I'm going to excuse you at this time. All rise for the when I look at 605, the last two paragraphs in 605 seem very similar to 515, which is read after the closing arguments before the jury goes out. And so I was looking for something as a way to kind of conclude the matter, as opposed to the last argument is made and I just say, go. So my suggestion is, if I read the instructions in the order that you've proposed, other than moving 160 to after 605, other than that, I'm proposing that I give a modified 460 just before the jurors leave. So after closings, I give a modified 460. 460 is the instruction, and I'm having my judicial assistant draft that up. That's the one that says something as follows, and I know you gentlemen have heard it before. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. It's that instruction. And the only thing I would eliminate is the second paragraph of that instruction, which says, you are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. I delete that paragraph because, first of all, this isn't a question of guilt or innocence at this phase. And secondly, because they're actually informed about the consequences of their action when I read 605. So I think that paragraph should come out. But in exchange for giving the instructions before you close, my suggestion is give that modified 460 after your closings. I then swear the bailiffs and send the jury out. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Okay. I gave you the proposed verdict forms, and what I noticed as I was looking at them, there's spots for the dissenting jurors to sign, but there was no spot for the foreperson. My judicial assistant is making that change. So what I'm going to do is I'm going to go make these revisions and then bring them back to you. But there are a couple of other things I need to call to your attention. First of all, a change that I made in 100, the opening instruction, is in the third paragraph. You should have that. I put it in bold. That if any member of the jury has an impression of my opinion as to the issues in this phase, disregard that impression. That would take the place of the language that's given in the first phase, which is if any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty. So I switched that. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then Mr. Freilich, I need to speak with you, and perhaps you need to speak with your client about whether you want me to give 315. That's the instruction that your client during the first phase elected that I give. That's the instruction that says a defendant in a criminal case has the absolute constitutional right not to testify. And that's really, she has an option to have me give that or not give it.
Talk to my client. We both agree that you could read 315.
You're asking that I give that.
Yes, I am.
Mr. Business, you've had an opportunity to speak with your attorney about that decision?
Yeah.
Okay. And I know you spoke with him about it at the beginning of the first phase. You'd like me to give that instruction in this phase?
Yes.
All right. I'll give 315. 640, mental disease or defect expert opinion testimony. The interesting piece there is that the last paragraph, the court has appointed, and then it says to fill in the name. Two of the people that were appointed by this court testified. Only one on the NGI piece, but two of them testified, and they both testified they were court appointed. And it indicates that you shouldn't give give their testimony any greater weight. I think probably both of their names should be in there, but I could see an argument that only Dr. Engen's name should be on there because she was appointed on the NGI. On the other hand, they were both appointed by the court, and the notion that they shouldn't be given any greater weight than anybody else seems to apply to both of them. Mr. Saunders, any opinion on that?
Not really. I guess the preference would be to include both.
Mr. Freilich?
It would be my position that we would only use Dr. Christina Engine because she's the one that did the NGI evaluation.
Okay. I'll just give Dr. Engens, would keep pronouncing her name differently. I've heard it pronounced both ways. Is it engine, like an engine, or is it Engen? I thought I heard her say Engen.
It's the latter.
Engen, I think.
That's how I'm going to pronounce it. Moving on then to 605, there are some options that we need to address. And that is under the subheading meaning of mental disease or defect. I have some thoughts about which ones seem appropriate given the evidence, but let's just run through them. The first option is, because it indicates that in that particular portion, add the following if supported by the evidence. First, temporary passion or frenzy prompted by revenge, hatred, jealousy, envy. That just doesn't seem to apply. I don't think it should be inserted. Agree with that, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I do.
That'll be out. The next one, an abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. Mr. Saunders?
I think that should be included. Particularly there was testimony about the criminal conduct, but antisocial, I think that kind of fits into a lot of the jail conduct reports, other behavioral things that the defense has raised.
Mr. Freilich?
I disagree. I didn't hear any doctor or professional say anything about antisocial conduct. So I would object to that.
I'm going to give that instruction for this reason. There was a lot of testimony about conduct that the average person could characterize as antisocial. And I think that's to keep that in. I note Mr. Freilich's objection, but that's going to be the order of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. I note that the parties stipulated at the last phase that should come in.
I'll agree.
Okay. The next one is a temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Mr. Saunders, you're asking for that?
Yes.
Any objection, Mr. Freilich?
Yes, I would argue that it's duplicitous. It's doubling up. The paragraph before is, I think, says enough. It's mentioning it twice, basically.
So, well, I think the difference is voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. The other one is a temporary mental state. The other one referenced temporary mental state versus voluntary intoxication. Temporary mental state, which is brought into existence by the voluntary taking. And I think that's consistent with some of the testimony that has been offered here. So I understand the argument, Mr. Freilich. I'm going to include that option. I think it's appropriate in light of the evidence that's come into this to this case.
Your Honor?
Yes.
One more argument, and I respect the court's ruling, but just to make sure I'm doing my part, is that just saying it a different way? I would make that argument too.
Well, a voluntarily induced state of intoxication by drugs or alcohol does not constitute a mental disease or defect. And
I was just saying it a different way, in my opinion, my humble opinion.
Mr. Saunders, any response to that?
Yes, I think they're pretty clearly different. A voluntary induced state of intoxication refers to using methamphetamine, using alcohol, using some other illicit substance. A temporary mental state brought into existence, I think, refers to the circumstances that Dr. Engen testified to about meth-induced psychosis or symptoms that are brought about by use of substances, because that speaks to the mental state. Induced is basically the same thing as which is brought into existence. So I think they're different.
Okay, I think the difference, Mr. Freilich, in response to your objection is for someone to be in a voluntary induced state of intoxication, the jury couldn't find that that's a mental disease or defect. The next option is if a mental state exists, if there's a potentially a diagnosable mental state that exists on a temporary basis, so not just the intoxication, the mental state, which was brought into existence by the use of drugs, that does not constitute a mental disease or defect. I think they're different. So I note your objections and your amendment to your objections, but I'm going to give both of those because I think they're different.
Thank you, Your Honor.
The next then is chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Mr. Saunders?
I don't think this one should be given. We didn't hear testimony about the latter part of that there is some permanent, and we talked about this with Dr. O'Donnell, that there is some permanent condition that the defendant has. So I don't think it's an appropriate instruction to include.
Mr. Freilich?
I strongly disagree with the state on this. I think this language should come in. The court should consider it. I asked, I believe, Dr. Engen and Dr. Seipel, and I believe Dr. Layton, that, using drugs over time can cause brain damage. And so I'd ask that you allow that as part of the jury instruction, Your Honor.
Anything else?
Well, yes, it can, but there's been no evidence that if the condition has become permanent, that is something the defendant's afflicted by. So I don't think it's proper to instruct the jury on something that can be out there if there's no evidence that this actually is in existence. I think it invites speculation. I think it kind of is confusing to some extent as well. If counsel wanted to have an expert to testify about a permanent condition the defendant has, they could have done that.
Your Honor?
Yes.
It's crystal clear to me that this should absolutely come in. This young lady, Taylor Denise Shabusiness, was under a court order for involuntary medication and an order for civil commitment, which it doesn't happen very often. She was found by a court of law, by Judge Lee Joyce, to be mentally ill. And she was at the Nicolay Psychiatric Center for approximately a few weeks, where she was receiving injectable Abilify antipsychotic. She was getting treatment. And it was clear, the records replete with the fact that she had a chronic problem with meth, methamphetamine, marijuana. So I think it's totally on point, and that should be something that the court should consider. The operative word, in my humble opinion, is can. That word can. I think that makes it such that it would be applicable in this particular case.
I think the focus is if the condition has become permanent, and whether that's supported by the evidence. There's no doubt that chronic use of drugs or alcohol has come into this case. satisfied in light of the state of the record that it ultimately comes down to what the jurors heard. There has been a great deal of testimony regarding the use of drugs or alcohol. There were some questions placed to the defense expert about impacts on a person long term using various drugs. Satisfied the jury can assess that. I'm going to give that instruction. Certainly, the parties can argue that they don't believe the evidence supports that particular aspect, but I'm going to give that piece. So I'm going to include that, and then that's the last option that has to be selected. I'm going to make these revisions then, and then I will give you a final copy of them, and then we will move. We'll bring the jury back in, and we'll move to instructions and closings. All right, we are in recess.
Thank you.
It looks like we're back in business and we are back live. We're not behind anymore, you guys. Pelican. Hey, y'all, did the poll come up? Because I don't find it on my chat. Me too, Pelican. And you know what else? When someone passes you up just to turn like 2 streets down or the next red light or something like that. That would be nice because, tomorrow's Friday and they want to go home. They definitely want to be done with it. Probably before the weekend. But right now, I am listening to the trial and working on a live. Today makes 2 years that Michael Monkey Vaughn went missing. So I want to do a live about him tonight. And the little girl from Arizona, damn, I forgot her name, Navarre, I think is her last name, was found 4 years later. She went missing in 2019 in Montana. And I'm also going to mention that because I do have a theory of what happened, but I'll talk about that tonight. So if I'm late answering in chat, maybe that's why, because I'm doing that also while listening. I don't want y'all to think I'm ignoring anyone. And I will stay live during deliberations. Pass me and put on your brakes in front of me. I need to sing and right. I know, Pelican, that's something that irritates me. Like, if you're gonna get in front of me after passing me, you better be going a lot faster than me. Because I'm following you after. Like, not in a bad way, but, to be following someone speeding or something. But if they don't, like if they stay at a stop sign too long, if I think they're staying at a stop sign too long, or if the light turns green and they didn't go fast enough, let's see, like stuff like that, I'll, yeah, rage will come out. That's crazy, but you know what? It's getting better. So I think it's getting better. It might be getting better because I don't drive as much. I don't know. I've been sober for 14, wait, no, February, March, April, May, June. Tomorrow makes 13, 14, 15, 16 months sober. Yep. And July 7th made a year that I quit smoking cigarettes. You know what's crazy? Me either. So my all my other lives with the trials, the monetization was good. Um, but this one, for some reason, they put limited, and I don't understand why. All the other times they talked about the SA and the dildo and the what was left in the bucket with the head, all that, and they monetized that. But this one's limited for some reason. I don't know why, but I'll get it reviewed. That's crazy. Well, Pelican, quit smoking cigarettes, but I do still smoke marijuana. However,
Session, your silence is requested.
it's recreational
Okay.
here in Arizona, so I'm all good.
All right. Should have now a copy of the instructions that I propose to give to the jury. And again, I will give this before closing arguments. I'll start with the modified 100. There's one missing. Well, in any event, there's the add-on at the end of 100, but I'll get to that in a minute. I'm going to give 315. I'll give 640, the mental disease or defect expert opinion testimony. 605, instruction on the issue of the defendant's criminal responsibility. And then I'll give 160, closing arguments of counsel. Then you can do closing arguments. And then the closing instruction 460 after you've completed your closing arguments. I've added the verdict form, and the verdict form actually needs to have the heading on it. And I'll make sure that that gets corrected before it goes into the jury. But I did fix the request you had, Mr. Freilich. So the question one is, at the time the crime was committed, did the defendant have a mental disease or mental defect? And I did that for question two as well. And in the instructions, when I indicate you're going to be getting this verdict form, I made that correction there as well.
Thank you.
You know what? I think what I was thinking was missing. I don't think it is missing. I was thinking 602 needed to be inserted in 100. But that's true, but in the first phase of the trial. And so I think that's where I think I was thinking of 602, and 602 doesn't need to be inserted in 100 at this phase. Okay. That's what I propose to give counsel. I'm going to start with you, Mr. Saunders. Any objection to the form of the instructions or the verdict form?
Just on the verdict form, question one, I think it should read at the time the crimes were committed, plural, instead of the singular.
You're right. Because we're dealing with three, so that can be corrected. And then when I give 605, question one, at the time crimes were. Any objection to that, Mr. Fairley?
No, that makes sense. Crimes were, that's what we're talking about.
Anything else, Mr. Saunders?
Oh, there's one more instance. In the top of 605, the defendant's mental condition at the time of the offenses.
Sure. Makes sense as well. Mr. Fairley, any disagreement with that?
Your Honor, are we talking 605, the number one?
605, the very first sentence says, you have just heard testimony about the defendant's mental condition at the time of the offense, and they're suggesting it should say offenses.
I agree.
Anything else, Mr. Saunders?
I guess it's also on the next page, the first question heading.
What's on that same page? Number one. At the time the crimes were committed.
Okay. Those are fixed. And I don't think it appears any other place. Anything else, Mr. Saunders?
No.
All right. Mr. Freilich, anything concerns about the form of the verdicts or, I'm sorry, the form of the instructions or the verdict?
Your Honor, I see what Mr. Saunders was talking about on that second page where it's in writing. the first question is, and then it should say at the time the crimes were committed?
We've caught that already.
Okay, but on the first page, what I was talking about, we corrected that first paragraph with an S for offenses.
Yes.
But then if we look down, it says 2 questions, and then it's got question 1 and question 2. Was that changed to at the time the crimes were committed?
Yes.
Okay, I just want to make sure. Thank you.
And just so everyone knows, I'm not intending to go back and get that corrected now. I will make sure my judicial assistant corrects that as I'm listening to closings. And so when this is delivered to the jury, they will have it corrected.
Okay, thank you.
And in addition, as I've indicated, I'm also going to have the heading inserted on the top of the verdict form. So instead of the title of 605B, which is where this verdict form comes from, it'll have the heading in this case. If there's nothing else, then I'm going to use the same time limits as we had yesterday, but they're going to be flipped. So yesterday I gave the state a half hour and 10 minutes of rebuttal. That's what you'll get, Mr. Freilich, but the state will get 35 minutes for their closing. I'm not sure if you're going to need that much time. The time that I've given everyone each time, they haven't used, but I will keep track of that for this time.
Okay.
Anything else before we bring the jury in, Mr. Saunders?
No.
Mr. Freilich?
No, thank you, Judge.
Very good. Let's bring the jury in. Which microphone are we using on the podium? That one? Sure. Right, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has any impression of my opinion as to the issues in this phase of the trial, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify but must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also consider the qualifications and credibility of the witnesses and the facts supporting their opinions. The court has appointed Dr. Christina Engen to examine the defendant and to testify at trial. You should weigh the testimony of Dr. Christina Engen as you would weigh any other opinion testimony. You have just heard testimony about the defendant's mental condition at the time of the offenses. You will now be asked to determine whether the defendant is not responsible by reason of mental disease or defect. This issue will be presented to you in the form of 2 questions. First, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Second, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law. You will be asked to answer the second question only if you answer the first question yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that the answer to that question should be yes. Evidence has a greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. The first question is, at the time the crimes were committed, did the defendant have a mental disease or mental defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because the unnaturalness or enormity of the act, or because a motive for the act may be lacking. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol or both does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of the mental disease or mental defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? If you answer both of these questions yes, the defendant will be found to be not responsible for the offense and will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, you are to consider only the issue of the defendant's mental condition at the time the offenses were committed. Agreement by 10 or more jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching agreement. At least the same 10 jurors should agree in all the answers made. I ask you to be unanimous if you can. At the bottom of the verdict, you will find a place provided where dissenting jurors, if any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below them may be used for that purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. Now, ladies and gentlemen, the attorneys will make their closing arguments, and as indicated, because the different burden of proof in this case, Mr. Freilich will start. Mr. Freilich, are you prepared to make a closing argument?
Yes, Your Honor.
Go ahead.
Thank you. Your Honor, may it please the court, ladies and gentlemen of the jury, Mr. Saunders, Mr. Lissay. I want to thank you again for your attention. I know that you've been thinking and analyzing and listening very attentively to the testimony from these experts in phase 2 of this trial. Now, the question is whether or not Taylor D. Shabusiness is legally responsible for the crimes that she's been convicted of. And in this case, Taylor Shabusiness has elected not to testify. That's her right. You are not to use that against her in any way, shape, or form. This case is a battle of the experts. We have Dr. Seipel, we have Dr. Engine, and we have Dr. Lighton. The case started off by my client's father, Arturo Coronado, who came in and he testified that his daughter had some problems, some mental health problems growing up as an adolescent, that he got her some treatment, some counseling, some professional help, that he helped her at Nicolay Psychiatric Center, and that my client lived with him for a period of time. So he provided the framework and the background for some of the issues that this young lady has. And we heard about the fact that her mother died in the home, and she was there. And that was I would submit that was a pivotal event in her life because she loved her mother. Then we moved on to Dr. Diane Lighton, PhD, a doctor, forensic psychologist. And she provided testimony as to her extensive background, her training and experience. And she provided testimony that she worked at UW-Madison as a scientist, that she completed over 3,000 hours of post-doctoral training at Mendota Mental Health Institution, a well-known institution that treats people with mental health problems, and that she became a licensed psychologist in 1993. She worked there doing competency evaluations, NGI evaluations, many other evaluations. And then in 1997, she went and became an independent forensic psychologist, where she conducted hundreds of forensic evaluations, including competency, NGI, not guilty by reason of insanity or not guilty by reason of mental disease or defect. We call it NGI. Evidence-based sentencings and guardianship. And so she testified about her background and her resume. Lawyers call it a curriculum vitae, her CV, bores out all of the experience that she has working in this field, technical field. And she went on to testify about the fact that she met with Taylor Shabusiness in February of 2023 at the Brown County Jail. And Mrs. Shabusiness was nonverbal, non-responsive, apparently threw a chair. She tried another approach where Dr. Lighton met with her behind glass and didn't really get any response. Then we heard about the fact that she did meet with Ms. Shabusiness in June of this year, and she was able to conduct her interview and glean and garner information with regards to her mental status and this report that she was tasked with. And I submit that Dr. Lighton testified that she didn't have to do an MMPI, a Minnesota Multiphasic Personality Inventory. She was able to gather enough information from reviewing all of the other materials and information that she had. Interviews, consults with the prior attorney, with me, reviewing all of the other doctors' reports, Dr. Lucetta, Dr. Seipel, Dr. Collins, and other doctors that have been involved in this case. She reviewed police reports, looked at interviews, looked at the criminal complaint, looked at Brown County jail records, looked at Nicolay Psychiatric Center records when my client was inpatient there, looked at her school records, looked at the Bellin Health records, looked at a lot of information. Basically, what we have here is Dr. Lighton, who's very experienced. She did the NGI evaluation. You heard from Dr. Seipel, Matthew Seipel, that he did a competency evaluation. He did not do the NGI evaluation. Dr. Christina Engine, she's the one that did the NGI evaluation. Now, as it relates to Dr. Lighton, she is of the opinion, to a reasonable degree of psychological certainty, she testified that Ms. Shabusiness, Taylor Shabusiness, qualifies for the NGI plea based on her diagnosis of a serious mental disorder. The serious, she opines, she concludes, that the serious mental disorder affected Taylor Shabusiness's ability to know right from wrong at the time of the alleged offense, dating back to February of 2022, and affected her ability to control her behaviors. And she finds and opines that Taylor has been diagnosed with bipolar disorder for at least several years. And that was confirmed in the records from Bellin Health. She also says and opines that Ms. Shabusiness continues to have prominent psychotic symptoms and has not used substances for at least 1 year. There was some talk about the feigning, the faking, the malingering. Feigning means faking. About that topic. And Dr. Lighton indicated that it was her opinion that my client was psychotic at the time of the alleged offense, and it wasn't simply due to drug use. It's clear that Taylor Shabusiness had a problem with methamphetamine, with drugs, marijuana, other drugs maybe. Dr. Lighton says that Ms. Shabusiness had a very strange presentation, had facial expressions that can appear inconsistent with the context. If you're talking to her about something, she might smile or grin, and it may not be the appropriate time for that. But she opines that her assessment finds that Taylor Shabusiness has a genuine mental disorder of a psychotic nature, which is most likely bipolar 1 disorder. Now, in this case, you heard that Dr. Engine, with respect to her, she didn't know that my client was under a civil commitment order for Brown County by Judge Lee Joyce. Taylor Shabusiness was found by the court to be the subject of a civil commitment, and that's why she went to Nicolay Psychiatric Center. My client was also the subject of an order for involuntary medication. She had to take medications ordered by the court. No ifs, ands, or buts. Why? Because she was deemed to be having a mental illness. So that's something, ladies and gentlemen, that you should really strongly, seriously take into account, that in April of 2021, for a 6-month period, she was under a civil commitment order because she was mentally ill. When you look at you know, the report from Dr. Seipel, or you heard about his testimony, I would argue that, you know, his focus is on competency, and competency and NGI are two legal theories, two legal issues that have to be determined separately. But his focus is on competency, and that I would argue that his testimony is not relevant, not germane to the issues that you are tasked with, and that is to determine if my client is NGI, if she meets that criteria. Dr. Seipel, although he's a PhD, you know, his training and experience is much less than Dr. Leighton's. But his focus was competency, and that's not why we're here. Dr. Engen, she testified, and she met with my client on October 12th, 2022, and then again on October 21st, 2022. It appeared that on October 12th of 2022, there was some security issues, so she wasn't necessarily able to meet with my client. But she did meet with my client on October 21st of 2022 and had a 3-hour interview with my client. That's 9 months ago. It's a long time ago. I would argue and submit to you that her report is stale. She didn't receive the Bellin records. She didn't look at those records. Someone else could have given her the records. Maybe Dr. Seipel, he's on the same letterhead. And Dr. Seipel knew that he was doing his evaluation. There was a disconnect. There was no communication between the two doctors, which is something you should consider. There was no connectivity there. Also, with due respect, Dr. Engen, you know, didn't trek from Milwaukee to the Brown County Jail to meet with Ms. Shabusiness to do further assessments or supplements. Didn't do anything to supplement the report. So that's something you should take into account as well. There's an instruction, I believe the judge already gave it to you, but it indicates chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. Something to take into account here. We believe that Dr. Leighton was very clear that Taylor Shabusiness has bipolar 1 disorder, that she has psychiatric symptoms, she has mental health problems. And she made that clear. She talked about the fact that Taylor Shabusiness heard the train, heard the whistle, that Miss Shabusiness lacked volitional control, lacked the ability to control herself, that she is a psychotic person off the scale, that she has a very unusual presentation. And she testified that Taylor Shabusiness, when she interacted with Dr. Litton, that Taylor tried really hard to answer her questions. But Ms. Shabusiness was distracted by internal stimuli, the clock, the cord, voices telling her to hang herself, the train with the whistle that got louder and louder. Talked about 007 and James Bond when she was asked about her mood. Dr. Litton talked about hypersexuality, and that was a concern for Dr. Litton. And about OCD, obsessive compulsive disorder, where Ms. Shabusiness was washing her hands 30 to 40 times or touching her hair, things that were a cause for concern. You know, Wisconsin law, we all have to follow the law, and Wisconsin law is such that the defense and a defendant must satisfy you jurors to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, that Ms. Shabusiness had a mental disease or mental defect, and that as a result, she lacked the substantial capacity to either appreciate the wrongfulness of the conduct or conform her conduct to the requirements of the law. And you're going to be given some jury verdicts, basically questions. Not many, just 2, I believe. One is, at the time the crime was committed, did the defendant have a mental disease or mental defect? I would submit that the answer would be yes. That's my argument. That's my request that you consider that, and that it was bipolar 1 disorder, based on the testimony from Dr. Litton. Then number 2, you'll have to consider, as a result of the mental disease or mental defect, did Taylor Shabusiness lack the substantial capacity either to appreciate the wrongfulness of her conduct or conform her conduct to the requirements of the law? And you'll have to consider that as well. I would submit that would be a yes. And I know you know this, but I want to make sure the only issue at this hearing, at this phase 2, the second phase of the trial, is Taylor Shabusiness's mental condition at the time of the offense. So take that into account. It's a difficult case. It's a very complex case. Deals with law, deals with psychology, deals with mental health. A lot of things going on. But I would ask that you take all of this into account when rendering your decision. Thank you very much.
Mr. Jose, are you going to be good? Mr. Saunders, okay, go ahead.
Thank you. Good afternoon. I think it was the dope. I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Chad were toking methamphetamine beforehand. She even talked about how she was still tweaking on meth during the dismemberment process. Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth. And now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Shabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant question is at the time of the offense. Okay? And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis. There's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. You also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that. What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode? What part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash, just happening to be around the 5 minutes where she's actually strangling him and then the day that she dismembers Shad, it's utter farce. There's no basis for that. Instead, we're relying on a bipolar 1 diagnosis from April of 2021. It's a year before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court appointed. State didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent, really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law. You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect. If the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard. You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion, and that's the sole opinion the defendant's relying on to meet her burden. We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate if this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on, or her ability to conform conduct, right? We heard none of that. We heard a statement at the end that, well, I think she's NGI. I would support the plea. You heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern for me. That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experienced. We heard about that. But there are real issues with her methodology in this case. Based largely, her opinion is, on her interactions with Ms. Shabusiness on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel is exactly right. And you heard the testimony from Dr. Litton. Most of her opinions based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. For the last 4 days, there's no throwing chairs, there's no outbursts, there's no staring or off, right? So this idea that Dr. Litton's opinion based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you that would allow you to agree with her opinion that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer. You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so, with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball, right? Those are different concepts. And the information you heard about in the records from the testimony is that it's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes. that the court-appointed expert, Dr. Engen, observes. None of that, right? To the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right? And sure, Dr. Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. Shabusiness was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that. Didn't review the second interview, which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seipel's testimonies. He points out some of these issues. As he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert, and you heard the testimony. And if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar 1 disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or of a mental disease or defect. So when you're asked the first question, when you see the verdict form, that question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay. If you answer that question yes, and only if you answer that question yes, you get to the second question. Second question asks sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense. And really, it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too. But it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes, where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor. And what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over? She said yes. And why did she say it? Why did she say she did that? She was covering it up. Right? And that's why we ask those questions about the blood that we saw on the floor under the mattress isn't seeping through the mattress. It's coming because the defendant moved the bed over it, because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct. She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him. She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. Everything you're objectively seeing evidence-wise in this case shows you that she knows exactly what's going on. She even remembers details about this night. And now that we hear this professed amnesia in her comments to Dr. Engen about this offense, and you saw the interview, she had every detail down to the T. She could have drawn that entire basement for you from memory. Everything was located. She's telling you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on, even with the meth use. You have her memory of the incident. You're hearing about how she's describing, and you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct, yet you heard about the condition of that basement, right? Just pretty spotless, pretty clean, especially considering what happened down there. Because she cleaned up, because she was aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her conduct to the requirements of law. And again, you heard nothing from Dr. Litton to kind of help you with that, right? Like, okay, if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Litton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well, right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging in the time leading up to the offense. We heard about after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. Complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot of evidence that not only did she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so. And she did. You heard about her saying, well, yeah, I knew it was killing him, but the quote, I did it anyway, right? Because that's what she wanted to do. And again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect. We heard about the burden of proof, that it's a reasonable certainty by the grade of the credible evidence. And you should be, even though it's not our burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. Again, it's their burden to convince you that you should be reasonably certain by the greater weight of the credible evidence that she does. It's their burden. If they wanted the court's expert to review documents from 10 years prior, they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. If there was additional jail records, they could have produced those. And actually, Dr. Engen's comments about that make sense. You know, her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right? We don't really care. You're not asked to decide, does she have a mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing parents at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state, because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary. The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. Now the meth really didn't have anything to do with it. It's important to note, a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd. As a result, you should answer both questions no, or answer the first question no, and don't get to the second question. Thank you.
Mr. Fraley, do you have a rebuttal?
Yes, I do, Your Honor. Thank you. Your Honor, again, may it please the court, ladies and gentlemen, Mr. Saunders, Mr. Lissay. You know, this case illustrates that this young lady, Taylor Shabusiness, has a lifetime of mental health issues. She has bipolar 1 disorder. That is a mental disease or mental defect. You know, who is the state fooling? We have a young lady that was under a civil commitment order and a medication order by the Brown County Circuit Court in 2021. So she already had a mental health disorder, a mental defect, I submit a mental disease, that predated the incident that has brought us here to court on February 22nd of 2022. It's clear in this record that Ms. Shabusiness was at the Nicolay Psychiatric Center for 3 weeks or so, maybe a month in 2021. You got to see in phase 1 of this trial, Green Bay police officer Garth Russell, who parked his squad down quite a ways, and he walked in the dark of night across the snowy parking lot up to the Eastman Avenue apartment at 2353 Eastman Avenue. And Ms. Shabusiness Officer Russell met her at the door, out on the porch. And you could see on the video her face. You could see her eyes. You could see her demeanor. She didn't look right. I submit to you, she didn't look right. Something was going on. Did this happen when she was in a manic state or a psychotic state? I submit that, you know, once you have a mental health issue, mental health diagnosis, a mental health issue like bipolar 1 disorder, it's not going away. It follows you for the rest of your life. What we have here is someone who has a very serious mental health issue, mental health disorder. You pile drugs on top of that, it can constitute a mental disease or defect if the condition has become permanent. I would submit that Taylor has had mental health issues dating back to her early years. She went to Purveya, she went to Bellin, she went to Nicolay. She was under a court order where she had to have injectable antipsychotic medications. She apparently was psychotic when she was at the Nicolay Psychiatric Center. I would submit that it wasn't necessarily from drugs. She's got this underlying issue here. She has ongoing mental health issues. She's only 25 years old, and they've been going on since her youth. I would argue that the mental health issues that she has caused this whole situation, and that'll be something you have to think about. Is she able to appreciate, or was she able to appreciate the wrongfulness of her conduct on February 22nd of 2022? Was she able to conform her conduct to the requirements of the law at that particular time? And you saw the video. We all saw it. It was very bizarre, very unusual very odd, her demeanor. You know, in this case, there are a lot of doctors, but Dr. Engine, you know, she never knew about the civil commitment order. Come on. You didn't know about a court order? And she's a PhD and she deserves respect, but something happened here where it fell through the cracks that she didn't know about this civil commitment order or this medication order. And then we have Dr. Seipel, you know, he got the Bellin records, got them from me. And, you know, he does a report for this case, and I find it incredible. It's incredible that he doesn't send, with due respect to him, he doesn't send the Bellin records over to Dr. Engine, knowing that she's going to come in here and testify in a court of law in front of you jurors. I find that unbelievable. I don't make the law, but the law, you know the law because the judge read it to you. You have to consider whether she's responsible because of a mental disease or defect. So you've got to think about all of that. The defense didn't fail. There is a plethora of evidence to show her mental health history. Was her bipolar 1 condition permanent? I submit to you that it was. Did it cause a crazed situation for her on the date of this fatal incident? You heard Detective Groff, who's a very seasoned detective with the Green Bay Police Department. You heard him go through very methodically questions. He was patient. He asked Taylor Shabusiness lots of questions about what was going on. And he testified that the police detectives and the officers, it was an ongoing investigation and they didn't have all the facts. They didn't know all the things that were going on. It was evolving. Detective Scanlon was over on Stony Brook and Detective Groff was at the police department. She told Detective Groff, I didn't intend to do this. Me and Shad were buddies. Words to that effect. So I submit that she did not want to do this. At the time, was she in a state of psychosis? Who knows? That's for you, Saunders, Mr. Lassay, and I have given you the information, the evidence for you to wrangle with and think about and analyze and assess. I would ask that you consider the fact that Ms. Shabusiness was taking the antipsychotic meds, the injectable meds, when she was at Nicolay Psychiatric. And then once she was released, didn't take it anymore. We all know if you don't take your medications, you're going to have problems, especially if it's a mental health condition. If you don't take your high blood pressure medication, what's going to happen? Your blood pressure is going to go up to the sky and you could have a heart attack or stroke. Same thing rings true for other medications. And in this particular case, Ms. Shabusiness did not take these medications. So I would submit, her mental health problems, her bipolar 1, got worse and worse and worse and worse to the point where it went off the cliff. I would submit that based on everything that's been presented, I'd ask that you consider returning a verdict that she is not responsible for these crimes by reason of mental disease or mental defect as applied with the jury instruction. Thank you very much.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a fair, just, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. Do not be swayed by sympathy, passion, or prejudice. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. As with the case in the prior phase, you will be getting a copy of these instructions with you during your deliberations. With that, I'd ask the bailiffs to step forward to be sworn.
Do you swear that you will, to the utmost of your ability, keep all jurors sworn in this trial in some private and convenient place, subject to the direction of the court, until they have agreed upon their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do. All rise for the jury. Anything to bring up before we recess? Mr. Saunders? No. Mr. Fraley?
No, Your Honor.
Right. Now I'd ask, as with the situation the other day, I'd ask if everyone to remain around for 30 minutes until 6 o'clock or so. After that point, if you want to leave, if you could just leave a cell phone number where we could reach you. And with that, we are in recess. Thank you.
And here we go into jury deliberations. I will stay live, like you said. Hopefully, let's see. Yesterday they deliberated for 42 minutes exactly, but not really 42 minutes because for some reason I noticed they started the clock before they actually left the courtroom to go into the jury room. So it was actually less than 42 minutes. Thank you, Sherry. 29 minutes. I don't know why they started the clock early like that. And let's see, they started this clock at now. Okay, 48 seconds. So the judge is going to give them 30 minutes and then I guess make a decision if they're not done. So I was going to say, hopefully, since yesterday took 29 minutes, hopefully today will take that or less. I'm sure they already have their mind made up because they know she's guilty and they just have to listen to the evidence, which they just did, to determine if it's because of mental health or drugs. In my opinion, it's because of drugs. Anyhow, I'm still working on the live for Monkey Vaughn. If you didn't hear a little while ago, I said today marks 2 years that Michael Monkey Vaughn went missing from Fruitland, Idaho. Yeah, she is mentally ill, but Avery, like I said earlier, when you do like a speed drug like meth, or if you abuse Adderall, it intensifies your mental health illnesses. So when you have an episode like I have BPD, so when I have like an anger rage episode, it makes it like 1,000 times worse than if you were just sober having a regular episode. And so I can see in that instance her being able to do this. And that's what my opinion is. She had an anger rage and it was intensified because of the substance, and she was able to do what she was able to do. She is able, but if everyone diagnosed with bipolar community, he's kind of got that would not be good. Right. And that's what they always want to accuse mental health. But half, not half, like more than half of the world freaking is diagnosed with bipolar. Like I said yesterday, it's like when you go see a psychiatrist and they don't know what's wrong with you, they automatically say you have bipolar. So that would mean like every single criminal that commits murder or SA or whatever like that, they'll just say, "Oh, it's because I'm bipolar," and get away with it. Yeah, okay, whatever. Not. Yeah, wanted me to stay live during deliberations, so speak. Where are you? Oh, that was my first diagnosis. It was correct. It was actually, I'm diagnosed with bipolar, BPD, PTSD, and severe anxiety. Yes, I am a mess. But thanks to medicine and therapy, I'm doing a lot better. Um, what's your name? Where are you? Let me find your name. Um, the new people that came in here. Did y'all leave already? Jimmy Rhino, where are you? I know you better still be in here. Me, who, and Pelican. Where y'all at? Y'all left me, Kaz. Where you at, Kaz? Only Sherry and Avery are talking. Kaz said a new AC for sweet misery and then disappeared. Right, Sherry? I don't know if Avery got to meet them. I don't think so. I'm trying to make a thumbnail right now for live. So y'all just talk amongst yourselves. Please, Avery and Sherry. I'm not paying attention to StreamYard right now. There you are, Kaz. Oh yeah, I forgot. So when do y'all kids start school? Um, Nevaeh starts August 3rd, I think, next week. Dang, summer just started. Sane or insane, sane or insane, sane or insane in the membrane. Kindergarten. I guess it starts on the 2nd, and that's in, oh shoot. Oh, duh, that's in Arizona. Oh, there you are. Obviously, she has issues. I don't agree about the meth issue either, causing what she did. She stated she Oh, yes, ma'am. That's a wonderful idea, Avery. Why didn't I think of that before? Because my mind's on Michael Vaughn. Oh, so yeah. So me, who you don't think that the drugs had any play in what she did, that it was mental health issues? She definitely needs to get help, therapy, a counselor, someone to talk
Hey,
to. Hi.
tell him about the article that I sent you on
Are you at
Messenger.
work? Or are you off work?
They might
You so cut out, and I don't hear anything.
Hello.
Now I hear you. Now I don't hear you.
Can you hear me?
Now I hear you. Oh, look, Sherry's coming up. Hey.
Hey, girl. Hey.
Now I can leave my stream and go do what I need to do. Like,
What?
hey,
Don't you
Sherry.
dare. Hi,
I know
Sherry.
you're not doing that. Hi, Avery.
I wanted her to tell you guys about the case that I sent her.
I am.
Oh, well, I couldn't hear because
I'm
my
sending it to my
my internet did something and I couldn't hear what you were saying.
She better not leave us.
She
and I
better
couldn't
not.
hear what you were saying. I'm not.
Uh-oh, why am I spinning again? Mother. Mammy Tapper.
For a
This
little while.
internet. Swear to God. Okay, $150 a month for
That's me.
Wi-Fi. Can you guys hear me?
Yes, I hear you. And I think the circle is
I
from
know, dude. Shit's so
Tuesday.
expensive and it never worked. Do y'all hear me?
Oh, you could hear me talking
Do
about
y'all hear
my
me?
bill?
Yes.
You guys could hear me talking about my bill?
Yes.
Am I gone?
Oops.
I don't see any of us on screen. So I don't know who's gone and who's not gone.
What happened to Christy? Where'd she go?
She
Take
left
y'all
us.
off stream.
I hear like an annoying sound. It could be her talking, but I'm not positive. I don't know. Let me listen really hard. She's gone. Sherry,
I told you she's going to leave us.
the bitch left us.
Stranded.
I'll be damned. So what's up, girl?
I'm
It's our
just
show.
I'm just hanging out waiting for these people to come back. And
What
hopefully
do you
we
think? You think they're going to come back and say that she is?
guilty. Guilty.
You don't think they're going to say? Okay. Do you think they're going to send her to prison or to a mental institution?
Either way, it's going to be for life.
Prison.
You think prison?
I think prison.
Because of the drugs, because mental illness doesn't make you take drugs, right? You choose
Right. It
to do
doesn't.
that.
You're right. That's your choice, whether you want to do meth or whether you want to do weed or whatever you want to
Well,
do.
that depends. Wait. Hold on 1 second. That depends because a symptom of borderline personality disorder is doing dangerous things and putting yourself in danger by
No, it's not. No, it's not. I can
doing
dispute that.
drugs.
Well, I do know that
Yes,
some
it
people,
is.
yeah,
Hold
some
on, let me.
people with bipolar, they have manic episodes where they're hypersexual or they
Right.
shop and spend too much or
Right.
gamble.
Right.
I'm not,
Yes,
and this
um
is so pitiful because I actually do
that's
have
part of
all my degrees in psychology, but yet I can't remember if drugs is on the list of things that they might do. But I didn't hear everything that she was diagnosed with today because I was actually having to really focus on work. I did hear bipolar. But I
That's
didn't.
true. That's true, Mihu. Jeffrey Dahmer was sent to an actual prison, and look at all the crap he did.
True. And he was definitely mentally disturbed.
Right.
Okay.
And she's
Impulsive. Can y'all hear me?
infatuated with. Yes, we're just ignoring you.
That's what
Poor
I
Christy.
freaking thought. Okay,
What
listen
do you,
to what I have to say.
okay.
Wow, what is that on the
Hold
screen?
on a moment. What?
What is that?
What's
Oh,
what
it's
on the
that.
screen?
It was like a hexagon.
A white hexagon on a black screen.
It's
Weird.
back now.
Impulsive and risky behavior such as gambling, reckless driving, unsafe sex, spending sprees, binge eating, or drug abuse, or
Oh, drug
sabotaging
abuse.
success by suddenly quitting a good job or a positive relationship.
Okay.
Okay, okay. Wow.
And this is what I think happened. Inappropriate, intense anger, such as frequently losing your temper, being sarcastic or bitter, or having physical fights. But because of the drugs, this right here was intensified to the max level, if that makes sense, to where she could pause. It's
Mm.
probable that she could have, but she did because of the
But
drug.
you know what's weird
Now,
is,
BPD.
go ahead, sorry.
Go ahead. No, go ahead. It's okay.
What's weird is like when she during her interrogation and she laid out everything that she did,
Right.
like it didn't sound like she was in a manic state or a
Yes.
rage. It
That's
sounded
what the
like,
prosecution tried to say.
yeah, and it's weird because she was hitting, she called the pipe the bitch. So it was meth, right?
Yes.
But it's almost as if she had the opposite effect, like she was on a downer because she took her time and she played with him and she often referred to herself as being lazy, not wanting to do this, do that, being slow. So it's like the opposite of the effects of meth, which is so weird to me.
And it had nothing to do with her medication because she wasn't taking it.
Yeah. Yeah. So I don't know. I don't understand that. It's hard for me to blame it on the meth when, they even said like when they arrested her, she was calm and normal. And then the
Well,
way she
she
describes,
because she had already come down from her little escapade, from her
okay,
little, you know what
but,
I mean?
So she came down from the high of being on meth.
but what about when she did all
Right.
this to
And
him? Because it seemed more like she was on a low when she did all this to him because
so
she took her time.
what I'm saying is that they took meth before this happened. Obviously, it was her and whoever else was with her, and possibly him. I didn't listen to that, that much into it, but um, so during it, she was still high, and then possibly coming down at the end. And then by the time she was arrested, like done, um, and of course they were also smoking weed. So if possible indica, and when I was doing it, I was also smoking weed at the same time. So I can kind of see that, but I don't know if she was on like a downer such as benzo, painkills,
Diazepam.
stuff like that. Sure of, because dang, that's so dangerous. Y'all take a speed and a downer together. I know
So
my
tell
cousin
me,
does that, and it's so
tell me what happens because I've never used drugs. So tell me what happens if, okay, do you snort meth or you smoke it?
Or do you
I
inject it?
used both.
You smoke meth?
I used to snort and smoke.
Oh,
Okay,
But my
snort
so
it.
favorite way to snort it.
so tell me what happens if you smoke meth and then smoke marijuana at the same time. Are you
Nothing.
Does it
are
balance?
you
You just get you still speed.
So you're
Um,
still so you're still like on an upper. The weed
yeah, but
doesn't.
I will tell you this: the high from snorting and the high from smoking are two totally different things. The feeling of it, the high
that was
from
gonna be my next
snorting,
question.
yeah, the high from snorting to me what is more intense than smoking it. Like you're speeding, but you're also like having the like the gambling thoughts. Like I always when I was on drugs and in Louisiana, there's video poker everywhere. I was so addicted to that, you guys. Like it was so bad. Yeah, it was just so bad. Oh my god. Like you go to the casino at like 2 or 3 o'clock in the morning and it's nothing but people high on that. There's and stuff like that. It's sickening. But anyway, and when I smoked it, I was speeding, but not as bad as snorting it. And like I slept every night, not like snorting it. And I didn't have like intense rage like I did with snorting it. So I would say smoking it would be more mellow than snorting it. And in my opinion, now that I'm thinking about it, you're right. I don't think she would do that. Smoking it. But then again, everybody's different. You know what I mean? Like it could affect somebody totally different than it affects me. You know what I mean?
Well,
Because
they
our
never
bodies are
did
totally
mention
different. So if, huh?
how she used it.
Well, they have the pipe right there. Don't
Well,
isn't the
they did
pipe for
say,
smoking?
yeah,
Oh, yeah. Okay. Yes. Yes.
yeah.
Sorry.
And they did say that, I think they said, I questioned in chat, did they say she took 52 hits? 52? Is that what I heard? That's a
Is
shit ton. Like, I would never
wouldn't that?
take that many in
Wouldn't
a
she?
day.
Wouldn't she OD?
Okay, now the thing with ODing on meth. Now, I asked my ex about it because I wasn't sure. He did
Hey, Janelle.
prison sentences for manufacturing. Hey, Janelle, I said earlier that I was like missing you. I haven't seen you, but I've been doing these trial things and you've been sleeping. Um, all my friends in Australia are like missing most of the trial, and then I really don't go live at during the evening when I do the day trial. So they miss me. But okay, what did you ask me? I forgot. Or what was I
ODing on
saying? I
meth.
forgot.
With the 52 hits,
Yes.
because that's
So
got
I
that's
asked
gonna
my
be a
ex
lot.
that. And I don't know about 52 hits. Like, I don't understand. That would be like back to back to back to back to back to back, like all day. I don't understand. But anyway, he told me that the only way you could really overdose on meth is if you really take too much. Well, then your heart will explode, of course. So that's ODing on meth because of the speed, and your heart will race and it'll just blow up if you do
well,
too much.
my brother-in-law years ago, he crystallized his heart from meth. It
Oh,
didn't explode, but um
too much. How long he did it for?
well, see, he had quit for a couple of years, and then it was his birthday. He was going fishing with some friends, and my sister had given him like an extra $40 to get some drinks, and he went and bought meth. And it was his first time using it in a couple of years. And apparently he did like line after line after line. And he crystallized his heart and ended up in the hospital. And he did live. He lived, but he has, well, he might not be alive anymore. I don't know, because she ended up leaving him. But when he was alive, when I still knew him, he had very severe heart problems. Very, very severe heart problems. He was like not the same person. He didn't even talk the
Dang,
same
that's
way.
scary.
Huh?
Wow, I have been sober for 14 months.
Congratulations. I'm proud of you.
14 months. The last was with my ex, and when I kicked them out, that was the last time I ever used. And now I absolutely 100,000% know that I will not relapse because, um, and that's the two most calmer ways to do it. Um,
See, I'll
Oh,
be
I
thanks
honest
for
with
forgot
you.
what
moving.
I
I
was
didn't know
saying.
that.
Anyway, what?
I probably would have tried drugs in my life, but I have a fear. I don't know. I have like a just a bad fear that I would get something that was bad or made bad or maybe had fentanyl in it or I don't know. I have too many fears to because I've actually wanted to try
So
it just to see what it feels like, but
don't,
I'm too scared.
don't, because I was the same way, Avery. I did not smoke weed until I was 40 years old, and I did not try meth until I was 40 years old. And what happened was, my ex, I done told y'all, did manufacturing and did it. So I saw a commercial, and I swear to God, with everything in me, this is how it got started. I saw a commercial and it said, "Don't do meth. The first time you do meth, you will be addicted for life." And I'm like, yeah, right. Like, Kevin and his whole family and friends do it, like, whatever. So his sister now came over. He was in jail. His sister and brother in law came over, and I did it because I wanted to prove the fucking commercial wrong. Well, the fucking commercial proved me wrong.
Right.
So
But
just
this is
one
the thing.
time
So, Sherry,
you got addicted
yeah,
after just one time?
yep. Sherry, hold on. Let me explain myself because I haven't done meth for, like, let's say, all these years, and then I suddenly became sober 14 months ago. That's not what happened. I didn't do it constantly the whole time. I really only did it mainly whenever my boyfriend was with me, when I was with my ex boyfriend. And only a couple of times did I do it without him, without being with him in a relationship. So, Sherry, the whole time, like when I was in Tennessee with Siwa and at um,
Uh huh. Which by
Amber's
the
house
which
and all
by
that, it was
speaking of
I
Siwa,
was
I read that
sober
you guys were
because I was.
talking again.
Oh, what? I have never talked to that girl since that happened. You better tell them people to stop spreading rumors about me.
Okay,
I ain't never talked
on
to that girl.
on Reddit because she's been complimenting you lately. So they think that you guys are talking
Oh,
behind the
what?
scenes now. I
Who?
don't know.
No,
I
baby,
don't
no.
watch. I don't watch
No.
her damn channel. Okay.
What girl? What girl are you guys talking about?
I don't even watch her. How are we talking behind? I don't even want to do
I
this
don't
on
know.
this
That's what
live.
they just said. That's what they're saying.
But
Okay.
who? I
I'm,
want to know
I'm just
who.
letting you. I'm just letting you know.
Well, can I know who?
That's crazy. Well, I'm letting you know that the answer is no. I will never be friends with her or Amber, and that's just the bottom line. I don't care.
You
What
better
the hell
not
is
be.
she complimenting me for?
Not. I don't know.
Oh,
Not after what
so
she did to you. You best not be.
these are people I don't know. So
Okay. Siwa is
It's the
somebody that
well, Amber
that
is
she
the Amber
modded
channel.
for.
Um,
I'm gonna scroll down and I'm
gotcha.
gonna
Okay.
find that thread. So
but
keep talking.
I have
Did you know?
personal. I met her in person. I spent a whole week with her in Tennessee, in Gatlinburg and Pigeon Forge. Um,
Did you have your
and
boyfriend
then,
Rory with you?
huh?
Did you have your boyfriend
What?
Rory? Did your boyfriend
Shut
Rory
up,
come too?
Avery. I still never looked him up. I still not have not looked him up to see who he is.
I just want
So,
everybody to know that Christy is engaged to JLR's son, Rory, and his channel is Thou Shalt Not Kill. They're so in love. It's
Christy. Who
disgusting.
is Christy? I don't know Christy. I know Sweet Misery. Don't know a Christy. Sorry. What is Sherry doing? Bruh, you go on. I don't even go on Reddit. I haven't gone on Reddit. A lie. I went on Reddit to read about the Idaho 4 stuff, like just true crime cases, and
Okay, I'm here.
but
I
not
found
doing
that
anything.
thread.
I don't. Huh? What?
I found that thread where
Mom,
they're talking about you.
evidently, Siwa must be complimenting me lately. Why I don't have no idea. So people are thinking that we're talking behind the scenes. Please let these people know I have nothing to do with Siwa freaking Moon.
I haven't heard from Siwa Moon since
Tennessee.
Tennessee.
See, thank you.
Because it says, how long until they publicly announce that they've made up, allegedly, and start doing streams together again every night, going at everyone they dislike. And they go, wouldn't surprise me at all. Um, did you hear the nice remarks all of a sudden towards you that Siwa made the last few streams? She mentioned her quite a few times lately, and it was positive comments each time, which would be sus in itself, since she's always jumped at the opportunity to take jabs since their fallout. But there's a few other reasons I believe this to be true. It would also match Siwa's pattern, having a fallout with a friend, time to make up with an old friend again. And then there's more comments, but that's the gist of it.
It's okay. You don't have to read the mean ones about me.
No, there's no mean ones about you.
Really? How sweet.
No. They're all talking about her grifting.
Well, guess what? I promise you that I have nothing to do with her, and I have nothing to do with anyone that has done me wrong on YouTube. I don't talk to anyone that's done me wrong in real life, who are Amber and Siwa Moon.
Well,
But
there's one
everybody else, I don't give a
wasn't
crap or like whatever.
right. And I was like, ooh, are they talking? I'm going to ask her.
Girl, no, no. If I fall out with you, guess what? That's just your
I'm
bad,
done.
not mine.
Because I thought, if you go back to her after what she's done,
And that
I'll whoop your ass. I'll drive the 2 hours to Tucson, even though I can't see right now. But I'll drive to
that's
Tucson and whoop
you
your
are.
ass.
That's true. You only 2 hours from me.
Yeah. Okay, so
I
go back
don't
to
want
what
to
you were
talk
saying.
about drama on my channel, so I don't want to talk. I'm making my thumbnail for the live, so I'm gonna talk about. Yes, Avery, I'm gonna talk about that girl. Hold on. I looked it up on Messenger on my computer, but it won't let me open it. Megan Imarazawa? Is this in the
Okay,
United States? Yeah,
so for those of you
Michigan.
that know,
Megan. Let me.
well, Sweet Misery was, oh, Lord have mercy. She was
Ain't nobody in here knows but you.
uh, where'd Avery go?
I'm listening. I'm doing laundry.
Okay, well, she was a mod for somebody that treated her horribly, and I don't want to see her go back to that. That's all.
Not gonna. Don't listen to people. Rumors are rumors.
Right.
Okay, what am I reading?
So we were talking about
Released
meth and your
after
trip to
sentencing?
Tennessee.
Avery, is that it? The one that's really
It's about
released after.
the young girl in, I think it's Michigan. I want to say Michigan. Where is my freaking coffee cup? I want to say Michigan.
Yes.
I would lose my head if it wasn't attached.
I'm hungry.
Shoot, I just ate. I'm stuffed. I just had the biggest grilled chicken Caesar salad.
I had the rest of my salad from last night, but I only had like a little bit left. And that was like 2 hours ago. And that was
Me
all I
up.
had to eat.
I'm sorry, I thought I was muted. I'm all cleaning off my porch and everything.
Yeah, Janelle. Yeah, her.
Oh, that sounds so good, Kaz.
That does an egg and cheese sandwich.
Ugh,
Okay, here we go.
no,
This
egg with me.
mute yourself, okay? Please, thank you.
Dang,
Rude.
right?
Thank you.
Merowitz was released from jail. Take a look at this. This happened Tuesday, just hours after a judge sentenced her to 1 year in prison. She got the Megan was greeted here by her brother Ian and her sister Morgan, as well as a family friend. And the timing of her release was such a surprise. Our producer had to shoot this video on her phone for us. Merowitz, as you remember, was found guilty of the unlawful use of harmful irritants, chemical drain cleaner that she threw on her dad, mixed it with water in the process, and it resulted in severe burns and ultimately organ failure and his death. Now, earlier, Merowitz cried while she was reading to the judge her statement asking for mercy. And she shared with Court TV, get ready for this, Courty friends, she shared with us that another very well-known inmate helped her write the statement. Jennifer Crumbley. That's right, the mother of accused school shooter Ethan Crumbley. Yes, Jennifer Crumbley, who's still facing the pending charges, accused of giving her son the gun he used to do that shooting. Apparently, the two of them became good friends, best of friends in the jail. Who would have thought that would have happened? Well, Megan spoke to Court TV, giving us her reaction to the sentence and some insight into what happened the day that she tossed those chemicals on her dad. Let's watch.
Tell me what your reaction was when tell me what you were thinking when she pronounced sentence.
I was shocked. I definitely didn't think that she was going to give me a chance, but I was praying for a miracle today, and that's what I got. I was really happy.
You guys, she got a
This
year.
girl threw.
She killed her dad, and she got
So
sentenced to
this girl
a
threw
year.
lye on her father and killed him.
Yes, and she got
Was
one.
he abusive to her? What was her
I
reasoning?
I think so. That's why I was wanting you to look at it, because I think there's like a big backstory to it. But since I
Janelle,
know,
what do you know about this story? Come tell me what you know about this story. Y'all, Penelope is something else. She's laying on my mouse. She's mean. Okay, go ahead, Avery. Sorry.
I was gonna say, like, this is the best part about not being a YouTuber anymore and just being a sub. Now I can like throw cases at people like you and then ask questions and not have to know the answers.
So this comment right here says she shouldn't have spent a day in jail. What happened was an accident. I bet 90% of the population would never know that lye mixed with water would kill someone. Yet this teenager knew that? Please. That thank goodness for this judge who has a brain did the right thing. Do y'all believe that? Let's see what the comments say. But yet, someone who kills their abuser after years or of abuse, they sit in jail. She must have money. She don't look like she got money to me. Sorry, not sorry. Crazy. She deserves to do at least some punishment for this crime she did. How long did she do?
Wait, how do you look like you have money? Explain that to me.
I don't know.
Because
I just said that.
I've always heard that some of the richest people, they drive like clean cars and they dress clean and
I'm
stuff.
Googling it.
But
I'm Googling it.
oh, you're Googling it.
I look like I don't have money.
I don't know what I look like. I just look like me.
And like, normally people with money, like, remain kept, like, you know what I mean? Like, they have their eyebrows done, their hair done, their nails done, their feet done. But she just got out of jail, so she can't have all that done. You know what I mean? So I take back what I said. All right, let's finish.
And why do you think you got the miracle?
I think that Judge Valentine is one of those judges that's gonna give people chances. I think I got really lucky having her.
So tell me what you were thinking when you were giving your statement.
Honestly, I was just in the moment. I wanted every single word to be heard.
Wait a second. He didn't die till 5 months later?
That's a long
That right?
time.
Bruh, how can they prove that that's what it was? Did he ingest it? Where did he go?
And felt by everybody. Writing that took months, and at the very last minute, I finally found the words. So to be able to get those words out meant a lot to me. A lot was riding on them. So,
did you get any advice from anybody?
Yes, I have a best friend that's in jail, and she was with me through this whole thing, and she helped me with it.
And who is she?
Jennifer Crumbly.
Jennifer Crumbly, the mother of Ian Crumbly? And what advice did she give you?
She just told me to speak with my heart. She helped me write the things out that I didn't know how to put into words.
And what about, you also heard the letter from Austin and your Uncle Thomas. What did you think when they were reading that letter?
I was really angry because some of the things in there that they said about me weren't true at all. And I just wanted to stand up and make those corrections, but I was really hurt that my brother acts like he cares about my dad, but he's the one who hurt him.
The defense didn't offer an alternative theory. So what do you want people to know about that day?
I want them to know that I never threw any chemicals at my dad. I would never intentionally hurt my dad. And
What's the deal? Either she did or she didn't. Oh, he died from severe burns? Oh, okay. What's the name of that girl that was found in Montana from Arizona? What the frick is her name? Barry, what are you doing?
I'm listening to you. I don't know the name of that girl. I don't know who you're talking about.
I'll learn how to spell Alicia Navarro. Okay. Are you coming back up? Avery, come back up. All these kids have long names. What are you watching? You have your TV on.
Oh, dang. The volume is like so low you can't even hardly hear it. Okay.
What?
Me?
Yeah.
Yeah, it was so low I couldn't even hardly hear it. How could you hear it?
I can hear it.
Okay, it's turned even lower now, where it's like practically off. But I'm not even watching TV.
Damn, what did I say? Alicia. I don't know why I kept thinking Hannah. So, Janelle, you think that her sentence was the right thing to do? All right, let's go.
Everything that was ever said about it were lies that I can't believe were told. And knowing that my dad tried to tell them that it wasn't me, I mean, I feel like in the end, my dad always knew that I was going to come out of this. And that day, just, it didn't happen the way that everyone wants to say it did.
And he protected you right up until the end, it sounds like.
Yeah.
And how does that make you feel?
It makes me know that he loves me.
And how are you going to remember your father, Megan?
He's always going to be my best friend and the reason that I wake up every day. And no matter what, I'm going to live this life for him.
Wow. Okay, we're going to have more of this interview throughout the day. Again, Court TV exclusively interviewing Megan Mirowitz after her release there. We got that footage. We're the only ones to get that footage of her coming out of the jail where she made friends with Jennifer Crumbly. How about that? Who would have thought Jennifer Crumbly? Well, we'll be talking more about Jennifer Crumbly. She's going to stay in the jail for now.
Bro. Let's see where we're at on the clock.
We are at 38 minutes.
46 minutes, you guys.
Well, why does it say on long clock
38?
38?
Why do they have 46? It says 46:55 on my screen.
Oh, I just clicked live. Now it's 47. Oh, my bad. My bad.
I'm like, wait, I'm looking at the screen right now. Are you coming back? Let me see. I'm trying to do my phone.
I think I read somewhere that Taylor Shabusiness is, well, she's married, but her husband tried to say that she set him up because he's in prison, that she set him up at the same time that she committed this crime.
Mm-hmm.
And I don't know what he's in prison for.
Oh, really?
Yeah. But none of that was mentioned because it had nothing to do with what she committed here. Okay,
I
Janelle,
wonder
be
what the
safe.
judge is gonna do at 6. I wonder if maybe they talk to the jury to see at what point they're at, and maybe they're like, "Oh, we're close," so he's giving them extra time because he said 6 o'clock, and it's 6:17
It could
over
be.
there right now.
They could be all filling out their forms.
Hmm.
I mean, I'm trying to understand the purpose of this phase because there's no death penalty, right?
No,
This is just to determine
I
if she's
think
going to
what
go
they're deciding.
in a mental hospital or a prison, right?
I think yeah, they're determining if it's due to mental health issues, and then I guess the judge will decide because she's found guilty. So I think the judge may decide, in sentencing whether to send her to jail or maybe, he has the option for both. I don't know how that works.
Because she was found competent to stand trial. So that should say something right
Right,
there.
but that doesn't mean that
Oh,
she
that she wasn't
wasn't
competent at the time she did
incompetent.
it.
I mean, not incompetent. That doesn't mean that she didn't do the crime due to mental health illnesses, even though she's able to stand trial and
Right.
understand the trial and know her rights in the trial, then she's able to stand trial. But that doesn't mean that she wasn't ill when, that doesn't mean that
Well, then
it
she
didn't
should have
cause her
spoke
to
up
admit.
during the trial to say, no, I didn't know what the hell I was doing. You know, maybe that would have helped her. I don't know.
No, she should have done something.
Right?
What do you want, Penelope? She only needs something whenever I'm live. Like, really, dude? Nobody is listening in the chat. I mean, talking in the chat. Okay, I'm going to take it the car. Okay, be safe. I don't know what you're listening to. Maybe wait. Maybe the jury will come back while you're gone, and you'll have that to listen to. I don't know. My thumbnail kind of sucks. I don't want to turn my camera on because I look like crap.
Oh, let's take a look.
Look, let me
Oh,
show you.
she's Dave. Oh, she's just attacking her
Yes.
lawyer in this one for today.
Can
You
you
got just like
see?
you just cut a lot of different pictures and put them together.
No, it's Summer. It says our children, and then it has Summer Wells missing, Michael Vaughn missing, and Alicia Navarro found.
What thumbnail is that for? I don't see it. I thought you were talking about the one for now.
No, the one in my, the one on my that I'm showing in the camera. You'll have to rewind it. I already turned it off.
Well, that's why I can't see
What
it.
y'all want me to stay live for if nobody's talking? What countdown? Oh, never mind. It has been an hour.
We're at 53 minutes. Well, that one
All
lady
right,
today
I
said,
think
"Oh
I know
yeah."
what I'm gonna do.
One lady today said, "Oh yeah." People have been saying how she's been giggling and laughing and smirking, and it's like
Yeah.
that's because that's what she's been doing. Because she don't care. She thinks this is a game and a joke. So don't use that as an
Trying to do
excuse for her.
something. Huh? All right, let me see. I need to end this poll. Hold on. I need to find this chat. Where did it go? Did I close it out? Oh, there it is. All right. And
Yeah,
all
all
right.
them people, all
Now,
them people
let me,
voted yes, stay live. But where are y'all?
for real. That's what I'm saying. And Janelle's listening in the car, probably laughing her booty off. All
Avery, she's
right.
doing yard
Create
work.
a channel to join the chat. Okay. I'm huh?
Avery's doing yard work. Kaz is eating her eggs and toast.
Okay, let me see if this will work. Sherry, I'm going to put my phone outside the room as I go into StreamYard. I'll be right back. Talk to my people for just 2 minutes.
Okay, whatever you say. You're the captain of this ship. Oh, now there's two of you. Oh, we should be scared.
Okay. Avery's on the phone. Did you cook eggs and toast?
Kaz did. And now she's going to eat it.
I was out earlier.
Oh, there's a verdict already.
But anyway, I told you that Michael had it.
Did you hear me? Christy.
I'm coming. Hey, can you hear me?
Yes. I'm watching it straight from, well, I mean, I have their page up too, but Law and Crime, and I hear everybody saying, verdict is in, verdict is in.
Oh, really? Oh, cool. Verdict is in, people. I have to go smoke. I'm sorry.
Everybody's leaving when the verdict is in. Now, there they go.
Okay, mute yourself and unmute them.
They're not muted.
Okay, well, mute yourself.
Sure, boss.
Okay, thank you, lady.
The judge turns the sound on when he gets in the
Courtroom.
behind the bench. Yeah.
Okay, I'm muting.
I don't see the judge. Where is she?
Oh, I don't know, but the judge is there now.
Y'all, where is she?
Oh, I don't know, but here we go.
This judge is probably elated that it's finally over. Do you hear noise now? I wonder where she's at.
Oh, they're bringing her in.
Okay, cool.
Okay. Anything to bring up before the jury comes back, Mr. Saunders?
No.
Mr. Freilich?
No, you are.
All right.
So almost an hour. Dang, I wonder what that means.
Guilty.
She's laughing right now.
Is that Birdseye here?
Yeah. Oh my gosh. Right?
Okay, be seated. You are the foreperson, is that correct? Yeah. If you could hand your verdict to the bailiff. Okay. The verdict seems to be in order, and I will read it as follows. Question 1. At the time the crimes were committed, did the defendant have a mental disease or mental defect? Answer, no. There's no answer then for question 2. It is dated this date, July 27, 2023, signed by the foreperson. There were no dissenting jurors. Is there a request by either of the parties to have the Jury polled. Mr. Saunders?
No.
Mr. Freilich? Yes.
Mental health
Did this
issue.
last time, ladies and gentlemen. I'm going to poll you again. I'm going to start in the back. Ma'am, are these your verdicts?
Yes.
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 Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Start down here. Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Sir, are these your verdicts?
Yes.
Ma'am, are these your verdicts?
Yes.
Ladies and gentlemen of the jury, your service in this case is now completed. Many jurors ask if they are allowed to discuss the case with others after receipt of the verdict. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest you treat any discussion with a degree of solemnity, such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. It is in the public interest that there be the utmost freedom of debate in the jury room, and that jurors be permitted to express their views without fear of incurring the anger of any litigants or criticism of any person. Please respect the privacy of the views of your fellow jurors. Finally, I'd like to address you before you leave, so if you could just wait in the jury room for a few minutes, I'd appreciate that. And you may confer with me at any time before answering any questions from anyone. I wanted you to know that as well. And with that, we excuse the jury. All rise for the jury.
There we go. Guilty. And the answer was
And
no
having
for.
received this verdict as well as the prior two, does the state have a motion regarding the verdicts? Mr. Saunders.
I'd ask the court to accept the verdicts and enter a judgment of conviction. I do have a certified copy of a judgment of conviction, case 20 CF 998, as the basis of the repeater allegation in counts 1, 2, and 3 of information.
Those will be received. Mr. Freilich, any response to that request?
Your Honor, I bring a motion for judgment notwithstanding the verdict. I believe there's testimony, ample testimony in the record that my client was suffering from a mental disease or defect at the time of these offenses, and that she lacked the substantial capacity to appreciate the wrongfulness of her conduct and conform her conduct to the requirements of the law. I'd ask that you consider all of the testimony from Dr. Lighton, who's a seasoned veteran in the field of psychology, and the record. Thank you.
Thank you. I've listened to the entirety of the testimony over these last several days, and specifically regarding today's testimony phase. I'm satisfied that the evidence is sufficient to support the jury's verdict, and I'm going to adjudge the defendant guilty on count 1 of first-degree intentional homicide as a repeater, count 2 of mutilating a corpse as a repeater, and count 3 third-degree sexual assault as a repeater. I'm going to revoke bond at this time then, and I'm going to order an investigation report be conducted. I'll order that be released no later than 1 week in advance of sentencing, and then sentencing date. September 19th.
Let's check that out here. I already have a scheduled jury trial on September 19th and 20th, Your Honor.
26th.
I just have an inquiry. Would it be set for the whole day, for half a day? I've got hearings that day, but I could try to move some things around.
I understand, Mr. Fraley, and I'd appreciate it if you could do that. That's 2 months out. I have things on that day too, and you might be getting a phone call. You might be getting a phone call from my office asking if one of these cases can be moved, which will be easy to get permission for me to do that. But I would schedule it for 8:30 in the morning. I don't know how long it's going to take, but I would plan on the matter taking the entirety of the day.
Your Honor, I think I can move everything, but if it could it start at 9:30?
Sure, I don't have a problem with that. 9:30 in the morning. Mr. Saunders, I see you checking in the back with, I'm assuming with the crime victim. Is that an acceptable date to schedule?
Yes, I believe it is.
Okay. September 26th, 9:30 in the morning. I'll have that scheduled for the balance of the day. 9:30. He asked for it to start at 9:30.
Yes.
All right, very good. Anything else before we adjourn, Mr. Saunders?
No.
Mr. Freilich?
Your Honor, that pre-sentence report, if I only have a week, I can imagine this one's going to be long. Could I have a little bit more time, maybe get it 10 days before?
I will, here's what I'm going to do. I'm going to order that it be released no later than 2 weeks in advance of sentencing. This hearing is about 2 months out. I didn't count the weeks, but I think we can get it done in that amount of time because they tell us they can get them done in 6 to 8 weeks. So that's what I'll order. Okay.
Thank you.
And with that, the matter is concluded. Thank you.
Thank you very much.
And so that's the end of Taylor Shabusiness. Demon Shabusiness. Trial sentencing will be September 26th at 9:30 p.m. Central Time, 10:30 a.m. Holy crap, 9:30 a.m. Central Standard Time, 10:30 Eastern, and 7:30 our time. So of course I won't be up.
I know that's early.
Yes,
Her
everyone.
lawyer is still trying to get the judge to say, "Oh, she wasn't saying. She wasn't saying," even after the jury just said that she was.
I don't know. I think he was scared of her. I don't know.
He had
I
backup.
guess we'll just, yeah, but still, like, nobody wants to get, you know what I mean, to have somebody jump on them, even if somebody's gonna grab them off right away. No one, you know what I mean? Like, it's still such a sad situation. But
I get it.
anyway, I have been awake since 4 o'clock this morning.
Why
and
so early?
live since it first started because I woke up, to go potty. And then I was like, shit, if I go back to sleep right now, I'm not going to wake up in time for the trial. So I stayed up.
Oh.
You're welcome, Kaz. So I stayed up and then I went live on time. And
Well, that
here we
was
are.
a great sacrifice because I was not up that early. I woke up at 9 because the storm up here blew our power out at some point. I know I woke up at 1:45 and the power was out. And I get a text from SRP saying, "Oh, it'll be restored at 4:45." I'm like, "What?"
Dang, y'all power goes out every storm or something.
Well, no, this was due to the storm. The other one was like an underground wire, but it came on.
Okay.
It came on like 2 minutes later.
Let's see.
I smoked a cigarette and then it came back on. I said, "I'm going back to bed."
We had a good storm last night and the power blinked, but the wind is crazy. I never was in a monsoon before and the wind is crazy, but I love it. It's nothing at all like a hurricane or a tropical storm.
Well, we got a severe weather notice that was in effect until 9:45, and it's like, oh, we don't even have no wind blowing, and you're saying we're getting a dust storm? So I went to go to the potty before I went to bed, and all of a sudden, then I heard the wind whipping and whipping, and I'm like, oh, I guess the dust storm's coming after all. And so I don't know what time the power went out, but when I woke up, it was hot in here. So yeah.
Y'all hold on 1 second before I end because I just saw Brian Koberger say that they had new documents drop in the Brian Koberger case, and I just want to see what they are before I end.
Okay. So I'll sit here while Kaz eats an egg sandwich.
Bruh, that sounds so good. But we're having meatball spaghetti for supper.
Oh, see, I'm making diced potatoes with peppers and onions and kielbasa mixed together for dinner. So that's what I'm going to make. And Avery is over there doing it. I don't know what she's doing now. I don't know if she left or if she's still here. Janelle's gone taking her kids to school. And I think everybody else left us. Or they're in the bushes with Carly's used toilet paper.
Okay, so I think it's the state's response to the it's a motion to compel, and then they have the notice to the hearing is August 18, 2023 at 10:30 a.m. So that's all it is. It's changing the date from August 2nd to August 18th.
Oh, okay.
I think the documents are about, I'm pretty sure. So
And
go
that
get
was.
you some more food, Kaz. Make you another sandwich.
You should put some turkey bacon on that.
She might not have turkey bacon. All right, Sherry, I will talk to you later in Discord or something. I'm ending because it's time to end. I'm tired.
I will be there.
All right, everybody, have a good day. Thanks for watching and hit that like button for me, please. Thank
Okay,
you.
and I expect to see everybody else in Discord.